Good morning, all. This trial is in the matter of CFI 091-2024 and CFI 068-2024 and is being held by way of video conferencing before His Excellency Justice Michael Black, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Towers and Hamlins. Lead counsel is Mr. Matthew Watson. The defendant is represented by Pinsent Masons, and lead counsel is Mr. Lawrence Page. Thank you, Your Honour.
Thank you very much. Could we just deal with some housekeeping first of all? Mr. Watson, could you just map out what's been agreed between you and Mr. Page over the next couple of days?
So today, unless Mellon & Friends' time estimate has changed, is the evidence of Mr. Ivankovic for the entirety of the day. I don't know whether Mr. Page is ever able to update his time estimate, but that's certainly what's allocated. And then tomorrow would be the witnesses. So that's Mr. Al-Jazmi and Mr. Hyderabad Walla.
Yes, and Mr. Al-Jazmi is now going to give evidence in Arabic, is that right?
He is, and I think it was communicated both to the court and the defendants that I sort of put down a marker about whether my time estimate would remain the same, given that, because obviously with the involvement of an interpreter, it can sometimes slow things down. But I suggest we sort of see how we go.
Yes, when were we first told that an interpreter was necessary?
I think it was about Friday evening.
Okay. And Mr. Al-Jazmi has always conducted business in English, and all his interactions have been in English.
Well, Mr. Ivankovic doesn't speak Arabic, so
no. Well, all the documents are in English.
They are.
Yes. Okay. Right. Well, it's his right. Anything else then, by way of housekeeping?
There's nothing from me.
Mr. Page, anything by way of housekeeping?
No, Your Honour. Just in terms of Mr. Al-Jazmi, and he will explain for himself in due course. But as I understand it, his practice has been to use the auto-translate function in his written communications, and you may well have noticed from his emails that they are very well written in English. But as I understand it, that isn't that. I met Mr. Al-Jazmi last week, and it became obvious to me that he needs an interpreter.
Yes, well, he's entitled to an interpreter, certainly. Good. Okay. Shall we then proceed with Mr. Ivankovic's?
Yes. In which case, yes, I call Mr. Ivankovic.
Okay. Could we swear Mr. Ivankovic in, please?
Yes, thank you, Your Honour. Please, can the witness confirm whether they would prefer to swear on oath or by affirming?
By affirming, please.
Thank you. Can you please confirm your name and occupation for the court's record?
Steve Ivankovic. My occupation is that of investor.
Please repeat after me. I affirm.
I affirm.
That I will say nothing.
That I will say nothing.
But the truth.
But the truth.
Thank you.
Thank you.
Good morning, Mr. Ivankovic, and I'm conscious it really is morning for you.
Indeed.
Could we please go to page 74 in the bundle? Is that your first statement in the claim brought by Contessa?
Yes.
And if we go to page 83, is that your signature at the bottom there?
It is.
And if we go to page 105, is that your second witness statement in the claim brought by Contessa?
Yes, it is.
And if we go to page 111, is that your signature?
Yes, it is.
And if we go to page 640, Is that your first witness statement in the claim brought by you personally?
Yes, it is.
And if we go to page 667, is that your signature?
Correct. Yes, it is.
And if we go to page 690, is that the second witness statement in the claim brought by you personally? Sorry, Mr. Ivankovich, can you hear me? I can't hear you.
He seems to have gone on mute.
Yep. How's that? Yes, it is.
And could we go to page 706? Is that your signature at the bottom?
Yes, it is.
And are the contents of these 4 witness statements true to the best of your knowledge and belief?
Yes, they are.
Thank you. Please wait there. You'll have some questions from Mr. Page.
Mr. Ivankovich, good morning. You're not on camera for me, but I understand you are for others. So I'm just going to.
Yes, yes,
The name
yes.
is Lynch. He used the name.
So I just checked, Mr. Ivankovich. Does the name for you show up as Daniel Lynch on your computer?
I'm on 2 screens. One is showing Daniel Lynch, who's my attorney here in Chicago, whose offices I'm testifying from. And the second screen, it is showing no name.
I think I've now found you. Sorry about that. Hello, nice to see you, and hopefully you can
Likewise.
see me okay. Mr. Ivankovich, we're going to go through a number of different documents today, and I'll ask you listen to the question carefully and then answer if you can. If you need any further information from me, please let me know. Let's start with the Contessa claim. Do you recall that the first payment was made on the 26th of May 2023?
That sounds about right.
And that was before the contract was signed with KJM.
I don't specifically recall, but I think I testified that to my witness statement. Yes.
Yes. So the contract was signed eventually in about middle of June 2023. So when the payment was made, there were no written terms agreed. Do you accept that?
Yes.
In terms of the information available to you at that time about the yacht, as I understand it, the only document you'd seen was the Volvo Penta sea trial report. Is that right?
Well, no, I was given a general brochure from the manufacturer in addition to that report.
Well, we haven't seen that in disclosure, but what we have seen is the sea trial report. This is at page 857 of the bundle. Can you turn that up, please? And if you see there at the top, this was sent through to your lawyers originally, Casey Flitman at Moore & Co. on the 24th of March 2023. See that?
I do.
And then over the page, what we learned from this is we have a one photograph of the vessel, and at the bottom of that page, you can see that the survey was taken, or the sea trial was conducted about 4 months before this email was sent. Do you see that?
I do.
And the document focuses on the mechanical condition of the vessel only. You agree with that?
Yes.
And you were happy to proceed with the purchase based on that one document about this particular vessel. Do you accept that?
Not exclusively, but the document was part of my decision making to proceed.
Well, the brochure, was that a general brochure or a specific brochure for this actual vessel?
I recall being shown a general brochure by Mr. Al-Jasmi. What also convinced me to move it was I would categorize as very persistent and insistent pushing by Mr. Al-Jasmi to get involved in this transaction.
well, salesmanship, we might call that.
I wouldn't categorize it that way, but you certainly can.
Okay. So you had seen enough to know you wanted to, you were prepared to put money up for the vessel, and your purpose behind that was to earn a profit from it. Is that right?
Correct, yes.
So it wasn't the idea ever that you would purchase this to use it yourself.
That wasn't the intention.
And to the best of your knowledge, at the time you put the money in, it was sitting in Sino Eagle's yard, yes?
That's what I was told.
That it was fully complete.
That's what I was told.
And that turning on then, did you have a price agreed at the time you made the original transfer?
I'm sorry, can you please repeat that?
Had you agreed a final price for the vessel when you made the first transfer?
I do recall that there was a final purchase price mentioned to me.
Mentioned to you, but had it been agreed or not?
There wasn't a formal agreement. There was certainly an oral understanding among the parties.
So as at the 26th of May 2023, how much did you think you would be paying for the vessel?
In total, approximately $4 million.
The reason you moved quickly was because this was going to be a bit of a bargain. Do you accept that?
I do not. I moved quickly because there was constant badgering by Mr. Al-Jasmi. I really did not want to engage in this transaction, but because this was a new relationship, I wanted to be a good partner, and I thought the ultimate profitability of this venture would be good for the business, because we were delayed in delivering the product, which was just construction of vessels at KJI. So I made a commercial decision, which I thought would be in the best interest of the partnership and the long-term relationship.
And part of this commercial decision was that KJM had negotiated a $1 million price reduction. Do you recall that?
Well, I recall that was told to me. I had no independent knowledge that was true or not.
But you told it and you trusted and accepted that information.
I accepted it only in that what the final price, what purchase price would be.
And you had no reason particularly to doubt that, unless they were lying to you.
Well, that is certainly a possibility.
Well, at the time, did you think they were lying to you, or at the time, did you trust them?
At the time, I did not believe. I had no reason to believe they were lying to me.
So let's have a look at page 918 of the bundle.
Before you do, I'm very loath to interrupt cross-examination, Mr. Page, but can I just ask Mr. Vankovich to clarify an answer he gave a moment ago? For the transcript, it's page 8. The answer begins at line 4. I really did not wish to engage in this transaction, but because this was a new relationship, I wanted to be a good partner. I thought the ultimate profitability of this venture would be good for the business because we were delayed in delivering the product, which was just construction of vessels at KJI. KJI wasn't actually constructing any vessels in May 2023, was it?
Your Honor, we had begun with a small vessel whose project name was the Arrow. At the time, I believe we had purchased molds and were refining them. There was some prototype boats built at the time, I recall.
Okay, thank you very much. Sorry to interrupt, Mr. Page.
Of course. So, Mr. Vankovich, we're just going to have a look at page 918 in the bundle. And if we zoom in there on the first bullet point in the purple text, If you read that to yourself, please.
That is the bullet point that begins with "as you are aware."
Yes.
I'm finished.
You have no reason to doubt the accuracy of that bullet point, do you?
At the time, I didn't.
Let's move on to the survey itself. Do you accept that the survey was carried out between the 6th and the 10th of July 2023?
I accept that's what the document said.
And that followed a 5-day inspection of the vessel, yes?
That's what was portrayed in the document, correct?
If you had been shown that survey in July 2023, would you have said that the vessel was in a condition to be delivered?
No.
And that's due, as I understand it, to some of the defects in the vessel and the snag list. Is that right?
No. A document is simply a document. We Americans have many colloquialisms, and one of my favorite from Texas is, you can't really explain a horse to a man until he rides it. A typical process of a survey and inspection of the boat, it would be a physical inspection either by yourself or a trusted representative. So while that survey would have been a good roadmap or guideline to establish a baseline third-party review, it always is followed up by a physical inspection to check what is in that report as accurate and perceived correctly.
So to use your phrase, the riding of the horse, that would have to be done by you or one of your employees. Is that right? And not a surveyor?
Well, no, a trusted representative, and generally it would be with a surveyor.
Well, let's look at what happened here. So first of all, just in terms of the survey, then we'll come on to some of the surrounding story. You make no mention in your answer to me there about the defect, so that actually wasn't an issue then for you.
Well, it wasn't an issue because I wasn't given the survey in July of 2023.
Well, my question to you was slightly different. That if you had been shown the survey in July 2023, would you have said that the yacht was in a condition to be delivered?
Counselor, I'm sorry, I'm getting a terrible echo. Let me see if I can, if it changes if I take off the headphones. Can you try that again, sir?
Yes. My question to you is that if you had been shown the survey in July 2023, would you have said that the yacht was in a condition to be delivered?
Based on the survey alone, no.
And that was because of the defects, is that right?
In part, again, every single vessel we've purchased, invested, or financed in is followed by a physical inspection with the surveyor to go through the report, at least one.
Do you accept that this was a trade sale? It was a purchase from a manufacturer to effectively another manufacturer or a trade buyer?
If you could please clarify that question, I'm not really sure what you mean by a trade buyer.
Well, KJM are not an end user, correct?
No.
No, and KJM have its own facilities and can carry out maintenance works on vessels, yes?
No, that is incorrect. The KJM facility was in fact the KJI facility.
Well, KJM is able to arrange for maintenance of vessels and repairs, yes?
definitely not a vessel of this size and this nature. And as a matter of fact, one of the reasons we went into partnership with KJM and KJI was that they were a good maker of what I would say rudimentary finish of vessels that they had only had experience selling in the Gulf. They were by no means ready to sell vessels based on their fit and finish in a market such as the US or Europe. So I would disagree that they had either the capability, the facilities. The KJI facility was landlocked. So you couldn't bring a 70-foot vessel to this facility. There would have to be a third party wet dock or a dock with a huge crane rented to be able to service this kind of vessel. But I had no indication that there was the level of technology or expertise with KJM to be able to service this vessel.
You accept they could carry out polishing of the stainless steel?
I'm sorry, can you please speak up?
Do you accept that they could carry out polishing of the stainless steel?
There were staff on site that were qualified to do that, correct?
And other general maintenance like keeping it clean and tidy?
Not only could the staff of KJM or KJI do that, I certainly was qualified to do that.
Okay. What was the retail estimate for the vessel when you purchased it?
The range that I recall would be a net profit in the $1 million range.
So let's work on the end user price. As at May 2023, what did you think the end user price would be?
It would have been in excess of $5 million. That was the target.
And by the time that this transaction was happening, you had already been involved in more than 100 boat purchases. Is that correct?
That sounds like an accurate number. I've been involved in boats since I was 12 years old, so we've quite extensive. I couldn't give you an exact number.
So you tell us in your witness statement, paragraph 6, this is just at page 75, we just turn this up briefly. So you tell us there it's 15 years in yacht sales and charter business and approximately 100 boats. So I think actually you're saying to us, it's forgive me, but I think you're probably more than 27 years old as of today. So rather more than 15 years experience.
Yes, correct.
But otherwise that statement is accurate, is it?
Yes, it is accurate.
And when purchasing boats, snagging, dealing with snag lists on new build is entirely routine. Do you accept that?
Yes.
Do you agree that the surveyor's conclusion about the vessel, that it was satisfactory to good, was appropriate?
Those are very subjective terms, which is, again, common practice, almost religious practice when purchasing a boat, is you start with a surveyor's report, and you take that surveyor's report and often with the surveyor and review the specific list on the vessel. Those are subjective terms. I've never worked with this surveyor. Obviously, with surveyors that you work with in the past, that you're familiar with what they do, you develop a common language, and you tend to have an understanding of what is meant by satisfactory or good. Those were simply words until we had the ability to corroborate the document with the physical vessel.
Mr. Ivankovich, I just need to put this formally to you. I suggest to you that there's nothing in the report which justifies refusing delivery of the vessel. Do you accept that?
I don't accept it.
I suggest to you that any genuine trade buyer would have proceeded on the basis of the Admiral Marine Survey. Do you accept that?
That is a preposterous statement. No buyer of a boat of this size, complexity, or price would accept it sight unseen with a surveyor that they've never used before that wasn't contracted by them.
I suggest to you that KJM could have resolved all of the snagging points, even if Sino Eagle did not do so. Do you accept that?
Absolutely not. They've never worked on a boat of this size. Number one. Number two, that would have been ridiculous to do since these would have been warranty items to be snagged, and it would have ate into the ultimate profitability of the venture, which would have affected us. So all of those defects are common practice to be done at the yard under warranty work. There is a constant fight between the end user or the dealer and the manufacturer on what is covered under warranty. It's bad enough with American or British manufacturers, but to collect warranty repairs and monies from a Chinese manufacturer would have even been more problematic and complex. So, number one, I don't accept that KJM had either the skills or the facilities to cure those defects. And if they did, it would have been at a cost that would have eaten into the profitability, and that would have been just silly.
In terms of the warranties, do you consider it likely that the air conditioning units had a warranty attached to them?
Do I consider it likely?
Yes.
Well, they should have, but since I've never actually seen the contract of the purchase of this vessel, despite asking for it numerous times, it's impossible to tell what the manufacturer would have warranted or not warranted. So it's an impossible speculation because all of that would have been in the contract.
Let's move on to the story about what happened in 2023 and the arrangement of the survey and the events after that. Mr. Oliver Hand, tell me his job title.
He is director of maritime of our maritime operations within the family office. And when I say that, to clarify, the Ivankovich family office in general.
If someone were to go onto his LinkedIn profile, there's no indication there that he's a qualified surveyor. Is that right?
I've never seen his LinkedIn profile, so
do you know whether he is? Do you know whether he is a qualified surveyor?
I do not know.
Certainly, when you ask him to inspect yachts, it's not to do so as a surveyor.
No, we often bring a surveyor with us when he goes.
And Mr. Hand was a person who oversaw the purchase in 2023. Is that right?
He was involved in it with me. I overseeing is a broad term, but in the general sense, he was assisting in the purchase. So I guess that would be a yes.
Well, let's just follow through the story here. So we've already had a look at the email at page 857. If we can bring that back up, please. So what seems to have happened here is that Peruche has sent an email to Casey Flitzman, and she's sending that on to Mr. Hand and CCing yourself and Mr. Moore. Is that right?
That is correct.
Then the original plan was for Mr. Hand to review the vessel himself. Is that right?
By that, do you mean the original plan was for him to travel to China to inspect the vessel?
Correct.
It wasn't him alone. There was a qualified surveyor and maritime architect named Jan Thorvassen that was to travel with him as well.
Well, let's have a look at the documents. Page 900. So we have here, this is a WhatsApp exchange between Mr. Hand and I believe Mr. Al-Jazmi. And you see then on the left-hand side, there was Mr. Al-Jazmi sends through an invitation to Mr. Hand.
Can you please scroll that up so I can see the title? I'm sorry, down. Yeah, I see that this seems to be a text message from Mr. Hand. Where do you see Mr. Al-Jasmi's name?
Well, it's you see the text is in Arabic.
At the very bottom, I do see some Arabic text. Yes.
Also in the middle, and it's now been superimposed with an English translation of 23rd of May 2023. But you can tell the user here has a phone set to Arabic, the Arabic language.
Okay.
So
I mean, there's definitely Arabic on the page. Yes.
Okay, and let's just have a look at that letter itself. That's on page 899. And this is an invitation from the manufacturer for Mr. Hand to visit the premises. Yes?
Correct.
Now, we haven't seen any other letters of invitation to any surveyor. So you've just given me a couple of names, but there's no reference to those names in the documents.
In this particular document, correct, but it would be safe to assume that Mr. Thorvassen would have gotten his own document.
Well,
But my testimony is, and I believe it's in my witness statement, that Mr. Oliver Hand and Mr. Jan Thorvassen were scheduled to travel or planning to travel to inspect the boat in China.
Well, I suggest that it was Mr. Hand who was going to be going to see the vessel, and that he was not qualified to carry out his own survey. Do you accept that?
Well, Mr. Hand is a sea captain with decades of experience on boats. He certainly could have corroborated the aspects of the survey with the physical condition of the boat. He was not asked to be a surveyor.
And let's just have a look at your witness statement. You were saying you've already given testimony about Mr. Thorvassen. I think the relevant section of your witness statement is at page 78. If you read there, paragraph 18.
Unfinished.
There's no suggestion there that Mr. Hand was going to be accompanied by another person, is there?
In that paragraph, there is not.
And I suggest to you that the original plan was for him to travel alone to inspect the yacht.
Your suggestion would be incorrect.
And that the absence of any formal survey was acceptable to you.
It was not.
Now, Mr. Hand attempted to get a visa and discovered that he couldn't get one in time. Do you recall that?
That is an inaccurate description of what happened.
Well, let's just go back to the chronology because this matters. So page 899. So we see here the letter of invitation, and then page 900. A statement: tomorrow I will go to the embassy and see what happens.
This is an audio text. Please remain silent for the best result. This test is.
Sorry, there seems to be a test going on of the fire alarm system. Hold on 1 minute.
Sure. Shall I just wait?
Yep. There's it seems to be good. Go ahead. Let's, if it hopefully won't interrupt us again. I apologize.
So on the 23rd of May, there's discussion about going to the embassy on the 24th of May. We don't know precisely when the embassy visit happened, but it looks to have been around the 24th of May. Do you accept that?
It seems to be an acceptable date.
And it's around that time it was discovered that Mr. Hand wouldn't be able to get a visa in time to visit the vessel.
Well, it wasn't a question of in time, it's at all. And from what I do recall, the Chinese visa authorities required more information and the precise address from the shipyard, which Mr. Hyderabadwala refused to give him, and nobody from the shipyard refused to give him. So that, to both of us, sounded very, very strange. So it's not that he didn't get it in time. He was not able to because he wasn't provided necessary information from either the shipyard or facilitated by Mr. Hyderabadwala, from what I call, despite numerous requests, to be able to obtain a visa to travel there with Mr. Thurvasan.
Well, I suggest to you that KJM was happy for Mr. Hand to visit the vessel. Do you accept that?
I don't know if they were happy or not happy, but they certainly did not help or allow him to obtain a Chinese visa.
Well, they facilitated that visit by getting a letter of invitation from Sino-Eagle. Do you accept that?
Well, there was a letter from Sino-Eagle, but to my understanding, and according to the communication with the Chinese embassy, the information was incomplete and inadequate for him to attain the visa. So it seemed to me a half measure to go through the motions, but not actually complete the ability to travel and inspect the vessel.
So, and all of this happens on the 23rd and 24th of May, 2023. Is that right?
No, I think that's an inaccurate categorization. It happened over the span of a month. I recall that there was email and text communications to that extent.
Well, what we know is that the payment of 1.6 million happened on the 26th of May, 2023. So do you accept that by that point, it was still at best uncertain whether Mr. Hand would ever be able to visit the vessel?
That is correct.
And perhaps at worst, it was already known that Mr. Hand would not be able to visit the vessel.
Well, that's precisely why we made sure that that deposit was refundable for those unknowns.
And at that time, there, as we've already seen, there was no written agreement.
That is correct.
So you said you made sure it was refundable, but in fact, there were no assurances in place, were there, at that time?
There are no assurances in many things, but that was my oral agreement with Mr. El Jasmi.
That isn't stated anywhere. Let's have a look at the Admiral Marine process, page 910. So we have here the Admiral Marine quotation, and this was obtained by KJM. Can you help us with who Mr. Paul is? Do you see there at the top?
I'm afraid I can't specifically. I know that in the past, Paul has been a pseudonym that Parush Hyderabadwala had gone by. It is possible that this could be addressed to Parush, but it's very difficult to say from this document.
Okay. Then that quotation was sent through to you on the 13th of June. We can see this at page 918. And this is the email we've looked at a number of times. My version of it.
Is there a specific paragraph you'd like me to focus on in this document?
Yes, it's the fourth bullet point down.
That begins with hence?
Hence, yes. And if you see towards the end of that paragraph, there's reference there to the Mr. Enzo Hung as the surveyor.
I have completed reading that paragraph.
So except there that it was KJM who found the surveyor. Yes.
Well, it seems that Mr. Al-Jasmi found the surveyor. Again, when you say KJM, I believe he was acting on behalf of KJI because that was the venture we had together. But I think we can agree that it's Mr. Al-Jasmi who wrote this email regarding the surveyor.
Yes, and we can see that he uses the word we, and we don't need to break down what he means by we, but it's someone on the Mr. Al-Jasmi side of the fence who found the surveyor. Do you accept that?
I don't know it, but this was the surveyor that was found. So it was the group found the surveyor.
And if we look towards the top of this page now, we have a reply from Mr. Hand. If you see there, the second paragraph, he says, I will keep on pressing on my visa, but in the meantime, you should move on with the survey together with the surveyor that you are recommending. So he there is approving Mr. Hung. You see that?
Yes.
And then next paragraph, I also agree that time is of importance. I think he meant to say if the boat or as the boat needs to get to Dubai as quickly as possible. Except that's broadly what he's saying there.
It does seem to imply that there's clearly quite a bit of spelling errors in that paragraph, but yes, that seems what it says.
Yeah, and the general point being made is let's get the boat to Dubai as quickly as possible. The reason for that is that you couldn't sell the vessel until after delivery. Do you accept that?
Well, that's what was told to me. Yes.
And one of the other issues was that the more there was a delay, the more there might be other Aquila vessels in the market being sold, and so competition for this one. Do you accept that?
Well, no, that doesn't make any sense since Mohammed represented that they were the exclusive dealer of Aquila. So
well, let's have.
No, please let me finish, sir.
Yeah, of course. I'm so sorry. I thought you had. You carry on.
Thank you. That's kind of a strange statement because if any Aquilas entering the market would have come through our organization and Mr. Al-Jasmi. So I would say that the speed and the time is of the essence is the longer the boat sits in a shipyard, the more potential for defects and damage. So that is the reason why we wanted to get the boat delivered quickly and under our, what I would say, jurisdiction. There were no other Aquilas in the market. Mr. Al-Jasmi, KJM, and KJI were the exclusive importers and dealers, as I was led to believe.
Well, Mr. Rankovich, I suggest to you that's wrong. Let's go back to Mr. Al-Jasmi's email, at the bottom of this page, the final bullet point. Mr. Al-Jasmi there is saying time is of the essence, and you'll see why when you read on from that bullet point.
Okay, well, that's fine. It's unclear, but similar odds to be completed by Aquila.
Well, what I suggest to you is the answer you've just given is wrong, and that in fact this dialogue is all about getting delivery so that the Aquila vessel can be marketed and sold without any competition. There's no reference anywhere to defects developing on the yacht.
Well, that's Mr. Al-Jasmi's view. That's not my view.
And it's also not Mr. Hand's view, is it?
I don't know what Mr. Hand's view is, but if he was here, I think he would agree with me.
Well, he doesn't express any view about defects, does he, in that email?
He doesn't express any views on sales and competition either.
So I suggest to you that what we learned from this little exchange is that everyone is anticipating a quick completion and delivery of the vessel. Yes.
Well, time is money, so of course you
Let's turn
want to get the boat purchased and sold as quickly as possible.
Let's turn over now to page 920.
Before we leave that page,
Yes.
really just to flag up for myself when I reread the transcript, I do note that Mr. Hand refers to the problems with the address of the factory.
Thank you. Mr. Ivankovich, we turn through please, to page 920. Yes, it's now up on the bundle in front of us. So we see here at the bottom of this page, this then is the email which attaches the quotation from the surveyor. Do you accept that?
It seems to be so, yes, correct.
And although it's addressed Dear Ollie, if we look at the top of the email, it looks like that email made its way through to you as well. If we look at the top of the page, you see you are copied in two different email addresses there.
I am copied on this email, correct.
And do you agree you didn't respond to the 13th email with the surveyor's proposal?
Do I agree that I did not respond to this email?
Correct.
I don't see a response, no.
I'm so sorry, Mr. Ivankovich. I just lost you what you said there.
I don't see a response from myself. No, I do not.
Thank you. And then there's a further email on the 17th of June, where again, Mr. Al-Jasmi is chasing for everyone's views on the surveyor. Do you see that?
Are you referring to the bottom of the email dated
No.
13th of June, 2023?
I'm now looking at the 17th of June one, just at the top of the page.
Okay.
And
Yes.
so this is a further email. And again, you don't reply to that, do you?
I do not.
So these exchanges happen mid-June. We now know that the contract is signed on the 18th of June. Do you want to show you that document, or you have to take it from me?
You don't have to show it to me. I take it that that's an accurate statement.
Now, from page 921, it looks like there was then a video call between Mr. Hand and Mr. Al-Jazmi on the 19th of June. Now, just to explain 19th of June here, the date isn't on this document, but if you see at the top, there's some Arabic text there in the middle, just underneath the words Ollie Hand.
If the screen operator could please zoom that for me, that would appreciate that.
Just towards the top of the page, please. There we are.
Yep.
You see, now I'm no Arabic reader either, Mr. Ivankovich, but in the trial bundle index, we're all told that this exchange happened on the 19th of June 2023, and that, just for the transcriber's reference, is page 8, but Roman numeral 8 in the index. So, as we understand it, this exchange happened on the 19th of June, so the day after the contract was signed. And we can see here there was a call towards the bottom of the page. You see that?
Yes, I do.
You agree that it's likely that the parties were discussing the inspection of the vessel in that call?
I don't know what they were discussing, but there certainly seems to have been a video call.
Yes, and we can see in this whole exchange at the top of the page, there's the Aquila address is passed on, and it looks like they are trying to have a discussion about the Aquila vessel. We obviously don't know, but we have to draw an inference. Do you think that's a fair inference to draw?
I don't draw any inference from this text message other than they had a call on that date.
On the 20th of June, Mr. Hung's appointment was confirmed. Let's have a look at that at page 922. If we start at the bottom of the page, please. In fact, we'll start at 923 and read up the email chain. So just if we go down towards the bottom of that page, please. Thank you very much. So we see here, it's actually an email chain that starts on the 8th of June. So this is Mr. Hung saying, and then in the penultimate paragraph in that email, according to my schedule, I'll be available 26th to 30th of June. You see that?
Yes, I do.
And after that window, my next available day will be after 3rd of July. You see that?
I do. May I please ask a question, sir?
Yes, you may. Well, I'll see whether or not we can help you, but it may be that the matters come back later.
No, I just want to confirm that this email is between Enzo Hung and Paroush Hyderabadwala.
That's correct. So we're going to go through the email chain and you'll see that it's forwarded on to you. So I'm just setting out the history here for you. So that is a private email between Mr. Hung and Mr. Paroush. Then further up the email, the next email, if we just cross through to page 922. So again, this is a communication between KJM and Mr. Hung. This is now the 20th of June, 2023. And if we go again towards the bottom of this email, please. just after KGN provides its address, they're now locking in the survey dates of July the 4th to the 7th. You see that? Or they're suggesting a survey date of between those days.
Can you scroll down so I can see after the best regards, please? Okay. Yeah, this letter is from Wasim. Yes, that's what it says. Correct.
Yes. Then let's now go up to the top email on page 92. And the whole chain is then forwarded through to Mr. Hand and you on the 20th of June. You see that?
I do.
And they're explaining there, we take action with survey to visit the Aquila factory. Yes?
Correct.
So from this date onwards, you knew that the survey was going to happen between or likely to happen between the 4th and the 7th of July. You accept that?
That's what it says in the emails. Correct.
Do you accept that you had you were given a proper opportunity to comment on Mr. Hung's appointment?
I accept that I was copied on the emails. Yes.
And that Mr. Hand did take up that opportunity and he approved Mr. Hung's appointment.
That is correct.
That you did not take up that opportunity and you didn't comment on Mr. Hung's appointment.
That is also correct.
Thank you. Now, after the survey was carried out, you must have wanted to see the report. Do you accept that?
Yes.
Because you had paid up $1.6 million already, and this would be the first time there'd be a systematic review of the report itself. You accept that?
Can you please repeat the question?
So you had paid up $1.6 million by this point, yes? By July
Correct.
2023, yes.
Well, not me personally, but I'd arranged the payment to be made from our family office. Correct.
And you knew that the survey had happened in early July, correct?
Well, I based on this correspondence, I knew that it was planned to happen or it was discussed to happen.
Now, what we don't see in the emails is any chaser by you or Mr. Hand for the report itself. Do you accept that?
In this email chain, we do not see that. Correct.
Well, anywhere in the bundle during this period of time, summer 2023, there is no email that I've been able to find from you or Mr. Hand saying, where is the survey? Please send me the survey.
The bundle is vast and I haven't committed to memory, but if you can't find it, then you can't find it.
Now, by contrast, you were in Dubai personally throughout on a number of occasions in July. Is that right?
Yes, I did and do travel to Dubai frequently.
And my understanding is that you had 3 meetings with Mr. Al-Jazmi in July on the 21st, the 27th and the 29th of July 2023. Do you recall those?
I don't recall those meetings specifically, but I had every time I go to Dubai, I met with, I wouldn't say every time, but it was a custom of mine to meet with Mr. Al-Jazmi and visit the factory. Yes.
Well, let's just have a look at Mr. Al-Jazmi's witness statement, page 96 of the bundle. Paragraph 45, second line. He's had a look at his diary messaging apps and he can see that he met with you on those 3 dates and also the 1st of August. Do you accept that's accurate? Or...
I have no reason to believe it's not accurate. I don't recall those specific dates.
And so all these meetings happened a short time after the report had been prepared.
I don't know when the report was prepared or not, but those meetings probably did happen.
Well, have you looked at the report as part of your preparation for this trial?
I have.
And let's just have a look at it briefly together again, page 936. It's the first page, and turn through to page 942. Second paragraph, this report has been prepared specifically for KGM Marine on 10th of July 2023. See that?
I do see that, correct.
So it looks like this report was prepared on 10th of July, and then 2 or 3 weeks later, you are meeting with Mr. Al-Jazmi. You accept that chronology?
I accept that that is what it says, that when the report was prepared, and I accept that it is very likely that I met with Mr. Al-Jazmi in Dubai on those dates.
And you must have discussed the yachts on those dates. Is that right?
Not necessarily, no. Not this specific vessel.
And also the survey, yes?
When you say we must have, no, I actually don't recall that. We had plenty of other business to discuss.
Well, in terms of the money you had committed to the relationship by this point, this was by far the biggest investment you had already made. Accept that?
Oh, no, that is not correct. In the relationship, I had purchased a 100-foot Sunseeker, also at the urging of Mr. Al-Jazmi, and that was an $11 or $12 million purchase that I had already purchased at the time, and we were in the process taking a delivery on. So that is an inaccurate statement, sir.
So this $1.6 million was of no consequence to you. Is that your evidence?
That's not what I said. You specifically asked me if it was the largest investment of the relationship, and I simply clarified that it was not the largest investment of the relationship. The largest investment of the relationship, in addition to the investment of the factory, was the purchase of a 100-foot Sunseeker, also arranged through Mr. Al-Jazmi and Mr. Hyderabadwala.
Mr. Rankovich, what I'm just trying to explore with you is whether or not you are correct or incorrect in your evidence that you did not discuss this yacht at any of those 4 meetings. I suggest that you did discuss the yacht in those meetings because you had paid over a large sum of money to KJM.
Again, at that time, since this was probably 3rd or 4th on the priority list of my recollections, the first priority in those discussions was getting the factory up and running, getting productions of vessels going, establishing quality controls and designs of the boat. We were trying to manufacture the Arrow. The second, because this was a much more sizable investment, would be the sale and delivery and inspection of the Sunseeker. So this would have been down the list.
Do you recall having a further meeting in person with Mr. Al-Jazmi on the 23rd of August 2023?
Again, I couldn't tell you specific dates. It was my custom to try to make it to the office in the factory every day while I was in Dubai for at least a couple hours.
And let's, if you don't remember the dates, do you remember having a big set piece meeting with Mr. Al-Jazmi in late August 2023?
Again, I don't remember these meetings specifically, but I frequently met with Mr. Al-Jasmi. We were partners in a startup business, so I made it a point to spend as much time with him as I could.
And just to clarify, is your evidence that you can or you cannot recall discussing the yacht in these meetings in July and August 2023?
My recollection was there was a lot of discussion around the Aquila to get me to commit to the purchase. But after the initial deposit was made, it went quiet for a while. So as I testified before, the Aquila was, I would say, at that time, third or fourth on the priority list.
Well, let's have a look at some minutes of a meeting in late August. These are at page 1095. If we look towards the top of the page there, we can see present at the meeting was you, Mr. Al-Jasmi, Ollie Hand, Parouche, and Nathan Greenwood. Do you see that?
Yes.
And as I understand it, these minutes were prepared by Mr. Hand. Is that right?
From what I recall, minutes of meetings were prepared by Mr. Hand, yes.
So we can see here that the item 1 on the minutes is reference to the Sunseeker yacht, and that's one I think you've just referred to. Yes?
Correct.
And then items 2, 3, and 4 relate to the Aquila. Is that right?
I can't comment on number 4, what that's specifically relating to, but number 2 and 3 relate to a lease program that we were going to implement around the sale of the Aquila yacht.
So we have there, so you accept that 2 and 3 relate to the Aquila yacht?
2 or 3 relate to the lease program of financing the Aquila yacht to a potential buyer.
Okay, and we see there for item 3 talking about potential renters of the yacht, and then 4 talks about a service and maintenance plan to ensure the yacht is well maintained during rentals. So it looks to me like 2, 3, and 4 are all connected. Is that a fair assumption?
2 and 3 certainly are. Number 4 could be connected to the Aquila as well as the Sunseeker, but you could certainly include the Aquila in number 4.
Okay. So here you're discussing a pricing strategy for the Aquila yacht, is that right?
A pricing strategy for a leasing program specifically.
And this is all premised on taking delivery of the yacht itself, yes?
It is. Well, and more specifically on the sale of it to an end user that would require a financing package to purchase it.
And the only reason for having this type of discussion is you must have all been satisfied that the yacht will be delivered fairly soon. Is that right?
No, that's a stretch. I think we were planning on creating a leasing company within the KJI environment, and yacht leasing programs and finance programs were quite novel in the region. So we were going to use the Aquila and Sunseekers as test basis for a customer finance and leasing program.
And with item 4, it's Mohammed who's going to be preparing a service and maintenance plan to keep the yacht well maintained. You accept that?
Yeah, and again, since we were planning on selling the Sunseeker and the Aquila, as well as the other boats, part of our business model was to introduce a service sector as a profit center to the business. Also, hand in hand, when you are a retail financier of vessels, you generally will attach a mandatory service plan to those vessels to make sure the collateral is well maintained, and that logically was going to be run out of our KJI venture.
And you trusted Mohammed to put together that whole plan?
But whether I trusted him or not, I certainly asked him to.
So it's fair to say that if he was able to put together that type of service and maintenance plan, he would have also been able to arrange for the resolution of the 24 snagging items if it came to it.
No, you're conflating two different items. A ongoing service plan of preventative maintenance is a very different skill set than corrective actions and structural actions on a large yacht.
Let's turn over the page 1096. Just at the top there, see their deliverables, what has been delivered and what is missing from your point of view. There's no mention here that the survey is missing, is there?
On this document, there is not.
And the reason is that the survey had already been provided to you, Mr. Hand. That's right, isn't it?
No, I believe the reason is because the survey wasn't completed. Certainly not to my knowledge.
Mr. Page, I think, in fairness, the premise of that question is not entirely fair. If you look at the bottom of page 1095, Ollie will have a meeting with Mulder and Louise in Monaco next week, and we'll discuss the following. What has been produced for Octopussy up till now? What are the next steps? So deliverables relates to Octopussy.
Do you want to, what I'm about to do is important. I've put my case to Mr. Ivankovich. Let me put it a different way, Mr. Ivankovich, without locking it into any particular comment here. To accept there's nothing in this, in these minutes of meeting, recording a request by you and Mr. Hand for a copy of the survey.
Correct. There is nothing in the minutes of the meeting requesting the survey to the Aquila.
And I suggest to you that the reason why it's not being called for in this document is that you and Mr. Hand had already been provided with a copy.
I actually think your suggestion is incorrect. The reason it wasn't brought up is because it was our understanding that the survey wasn't completed and we didn't have a copy. Or else I think it's safe to assume that a discussion of that survey would have been included in the minutes of the meeting by your logic.
Let's have just before we move on from this document, item 1. And in fact, sorry, before I get to that, Mr. Rankin, just a follow-up question on the comment you've just made, or the evidence you've just given. The reason there was no discussion about the survey is that everyone was happy with the survey. That's the answer, isn't it?
We were certainly happy that the survey had been engaged, was in process, but I hadn't seen a copy of the survey until July 2024. So it's hard to be happy or not happy with something that you believe is in process, that is unfinished and that you've never seen.
Let's now just look at item number 1. There's a mention here to payments from Farhad. Is Farhad the buyer of the Sunseeker?
I would characterize Mr. Farhad as the manufactured and imaginary buyer that Mohammed and Parouche created to induce me to purchase the Sunseeker.
Well, we don't have time to explore all of that today, Mr. Vankovich, but from your understanding was that Farhad was the purchaser of the vessel. You accept that?
That was a person that I now believe was fictitious, presented to me to buy this vessel. He never put up a deposit, never signed a contract, never returned our calls, either to ourselves or the lawyers. So I will say it again. I believe Fahad is a fictitious person that Mohammed and Parouche invented to induce me to purchase the Sunseeker.
Was the Sunseeker ever sold on?
No, Your Honor, we still own it. Interestingly enough, we are still working with the factory on corrective actions for warranty work. But the market turned, and we did get offers to make a profit on the Sunseeker. This was just at the time when interest rates were spiking and the yacht market was softening. So we made the business decision to hold on to the yacht for the market to change. So we still do own it. And it will be actively marketed when we believe the market will turn to maximize profitability.
Thank you.
The price paid for Sunseeker 100 was that $11.5 million, Mr. Vankovich?
That is the price paid to the factory when you include shipping and duties and other things. The total cost was somewhere over 12 million.
Now
that's not including carrying costs at this point.
We're going to take a break shortly. I'm in your hands here. You content for me to carry on for 10 minutes or like a break now?
So I was planning to carry on until 25 past the hour.
Thank you. Then, Mr. Vankovich, if I can just detain you for a little longer, then we'll have our mid-morning break, or for you to your early morning break.
I'm happy to carry on all the way through. No breaks necessary here.
We have to take a break every 90 minutes or so for the court reporter. Otherwise, they will get a repetitive strain injury. So,
fair enough, Your Honor. Noted. Thank you.
Okay.
So let's just have a look then at an email chain relating to the Sunseeker. This starts at page 1103, and in the usual way, we'll read upwards. So bottom of page 1103. This is an exchange between Casey Flitman and Matt Folks, who was a surveyor. You see there, dear Matt, we represent Mr. Vankovich. We've received word from OWYG, that's One World Yacht Group, OWYG.
To correct you, just for proper nomenclature, it's One Water Yacht Group.
Excuse me, One Water Yacht Group. That the boat is ready, and that's a reference there to the Sunseeker. Is that right?
Yes, that is correct.
And we understand there's a snag list with items outstanding, and they're asking for a copy of the snag list. You see that?
That is correct.
Then we have Mr. Folks's reply, the 7th of September, just starts on page 1102. He says, yes, it's now completed to a satisfactory standard. There are a few points which are not yet signed off, but I've been told have been completed. Then final paragraph, if you need me to revisit the vessel or need anything from my side, please do not hesitate to contact me. You see that?
I do.
So Mr. Folks is saying he's ready for delivery, but he's happy to revisit the vessel if requested. Yes?
Yes.
And then we have Casey's reply on the 7th of February. Further up the page. They're trying to clarify who Mr. Folks is appointed by. And liaising with Ollie Hand about when to go back on board the vessel. You see that?
I do.
and then Mr. Fox replies towards the top of that page on a point of detail about the teak. You see that?
I do.
So what we can see here already is that as at September 2023, your group of companies, or your family's group of companies, had cash out on 2 vessels already, or perhaps more than that.
When you say cashed out, what does that mean?
Well, not cashed out, but excuse me, they had paid money out for 2 vessels. You'd invested 1.6 million in the Aquila and just over $12 million for the Sunseeker. Is that right?
That sounds about right, yes.
Now,
and I would say more vessels than that. I believed we also we probably purchased with Mr. Al-Jasmi another 3 or 4 vessels ranging from 28 feet to 54 feet.
So we can see in this email chain that for this valuable vessel, your lawyers are taking the initiative and they are chasing up on details of the snag list. You accept that characterization?
I do.
And I've suggested to you already that we don't see any email seeking the report or chasing up on details of the survey in the autumn of 2023 for the Aquila. You said there's a contrast there.
Are you asking me if a email chain specific to the purchase and surveying of the Sunseeker doesn't have any references to the Aquila? Is that your question?
No, we can all see from this document it's not talking about the Aquila. What I have put to you is that this exchange shows what happens when your family group of companies and your lawyers are concerned about snag lists and the level of detail they go into, and that we don't see that for the Aquila.
Well, I'm really happy you bring up that point, Your Honor, because I would categorize the activity and the purchase of the Sunseeker as the normal and customary activity to purchase a yacht of this price and size. And that would be a contract with the factory, a initial survey and review of the boat, corrective actions taken. So on the Sunseeker, there were at least 2, and I recall potentially 4 visits with Mr. Hand. I know on at least 2 of those, Mr. Hyderbarala was there on the boat with the Sunseeker. There were several sea trials with the boat. Again, this back and forth of review, physically inspect the review, make recommendations to corrective actions, come back, inspect, sea trial. And this is in Poole, England, which is much more accessible to Europeans and Americans, unlike China. I'm very happy, Your Honor, this was brought up. This is the perfect example and the normal way that a vessel of this size and cost would be inspected and accepted from the manufacturer. So this is the way to do it, Your Honor, and this is the way it was done.
And the reason for the contrast is because that there were no concerns about the condition of the vessel. That's right, isn't it?
I think concerns is a very dramatic word. There was problems with the vessel. Those problems were identified. They were in person discussed and reviewed. Corrective action was taken. The corrective action was again reviewed and inspected in person and either agree that it was done correctly or not. So
I think you're at cross purposes.
Yes, I was going to clarify. Yes.
Mr. Vankovich, you're talking about the Sunseeker,
yes.
and Mr. Page is talking about the Aquila. So
Oh,
Mr.
I'm sorry.
Page's question is the reason he's saying the reason why the procedure that you just outlined in some detail was not followed in relation to the Aquila was because it was known that the Aquila was a new vessel and there were no issues with it. That's the purport of his question. If I've misphrased it, Mr. Page, correct me.
Your Honor, I apologize. I in fact did not understand Mr. Page's correctly. No, at this point, Your Honor, there was no concerns with the Aquila because we had not gotten the report yet to be able to understand if there were issues with the vessel or not.
Let's move on just before the break, Mr. Vankovich, to the end of September, page 1106. This is an exchange between you and Harush, and he's asking there for the payment schedule for the 70 Aquila, followed by a wink, an emoji wink. Do you see that?
I do.
And your response is that you will send when I land. Do you see that?
Yes.
And as I understand it, if we then scroll through to 1109, that is the payment schedule that you then ultimately sent.
That is correct.
We can see that if we go back to 1106 again, we'll go through the chronology. So at the bottom of the page, you say when I land, and then on plane, and on the next page, 1107. In response there to a dialogue, well, let's try and liquidate the 70 Aquila. Then you send the payment schedule. You see that?
I do.
And then Perish responds to that on the next page, 1108. And again, you're discussing pricing strategy for the vessel, yes?
Yes.
And your reply is exactly 3 million. That's a residential on the lease and the bets we are making. You see that?
I do.
The word residential there, is that an autocorrect error, or what do you mean by that word?
Yeah, it seems to be an autocorrect. I believe the word that should be there is residual.
So what you and Parush there are discussing is about the structuring of an onwards sale of the vessel or leasing of the vessel. Yes?
No, we as discussed before, Parush and especially Muhammad were very interesting at the concept of creating a leasing or finance company within KJI. And this was me walking them through and explaining to them how a lease would work. It's my understanding that they were talking to members of the Emirati royal family or other buyers that were interested in purchasing the Aquila with a stapled lease program to it. So I was walking them through how a leasing program would work to a potential end buyer.
And let's just look again at the payment schedule 1109. And we see there it's clearly about the Aquila 70. It says so both in the title of the document and on the top left-hand corner of the spreadsheet. Cost of boat 5.45 million, and then setting out the structure of the payments. So down payment of 2.2 million. I'm assuming dollars. Is that right?
Yes.
And then residual value $3 million at end, and then an interest rate of 10%, or perhaps up to 16%. You see that?
Correct. Yes.
So the premise of these discussions must mean that the delivery of the Aquila is also being discussed. Can you accept that?
This was hypothetical on a sale and a lease program.
And if we go back to the first message in this chain 1106, you see there the emoji. What does that emoji mean to you?
Can you please the
Zoom in slightly on
the
that.
winking?
Yes, what does that mean to you?
A winking emoji. I don't know. Perhaps Mr. Hyderabad was being coy. I can't imagine he was flirting with me.
Well, I agree. He was being coy because really what he was saying to you here is he was chasing you for payment, wasn't he? But he was too polite to say so.
Your Honor, I did notice in Counselor's opening statement he suggested this. This is clearly the payment schedule for the lease. It's noted down at the end of this chain. This is how a buyer, that's what they were focused on. What is the monthly payment they could represent to a buyer for the Aquila?
Yes,
So,
I mean, I see that there are at least two documents attached to this WhatsApp exchange. There is an Excel spreadsheet for lease calculation, and there's also a Word document of 4 pages, CA agreement. I don't know what that is. Do we have those documents in the record?
The Excel spreadsheet I've taken the witness to, Your Honour, that's at 1109. I
Well,
don't believe we
sorry,
have
you said you've taken them to the spreadsheet there. I don't know whether that's the whole spreadsheet or not.
Your Honor, yes, that is, I recall preparing that as simply just a indicative high level
Okay, so
leasing
1109
model
is
for
a whole spreadsheet.
Yes,
Yeah,
I recall that.
But we don't have the Word document.
not to my knowledge, Your Honour, no.
Okay.
Now, your Mr. Rankovich, your response here will send when I land. I accept that you there are talking about the payment schedule, and that's what you do then send a week later on the lease calculation. But you don't make any mention here in your exchange about the survey, do you?
I do not.
And there's no suggestion that in your exchange with Parouche that it's now been 3 months and I still haven't seen the survey. There's no comments like that.
There is not, correct.
And again, it's the same point when you're doing the work a few days later on the 5th of October. Just turn over to page 1107. In response to Parouche's email or message saying, let's try and liquidate the 70 Aquila, you don't respond saying, well, nothing's going to happen until we get the survey. There's no comment like that, is there?
You are correct, Your Honor. It is not my habit to be proving negatives.
And when we then look at page 1108, your comment there, the bet we are making, again, your reference to a bet there assumes you are going to pay over the money. That's right, isn't it?
Well, there's lots of assumptions here. Number one, we're specifically talking about a novel lease program. And what we're discussing here is that the residual value of the Aquila after 3 years would be $3 million. It's a hypothetical based on a financial model represented in the spreadsheet. So,
and Mr. Rankovich, that then takes us to slightly after 12:30 UAE time. So I suggest we pause here for 10 minutes, if that's acceptable to His Honour.
Your
Yes.
Honour, I'm sorry, just before we rise, and I'm conscious that the transcriber needs a break. There is just a short issue that's arisen in the course of my learned friend's cross-examination, and it's to do with the document at page 921.
921.
This has got the Arabic date at the top, and I mean, neither my learned friend nor I speak Arabic, and my learned friend very fairly said that the index described this document as being dated the 19th of June 2023. I was told by the Arabic speakers who sit behind me virtually that in fact the date that one can see there in the Arabic is the 19th of May 2023. Now, I know my learned friend has Arabic speakers in his team. It strikes me that perhaps over the adjournment, they could look at it and the parties can see if they can agree that that is the date. And if
Yes,
it's not,
I tried to cut and paste it into Google Translate, but unfortunately, it wouldn't copy across.
it may not be very important, but it, you know, as the suggestion was made to the witness.
No, I want to be as accurate as possible with the chronology, of course. Thank you very much. Okay, well, I'm sure Mr. Page will check that with his instructing legal representatives. Okay, look, it's very nearly 25 to the hour. I think that's 5 a.m. Where you're sitting, Mr. Ivankovich, if I'm not mistaken. So we'll take a break.
Actually, Your Honor, it's 3:36 a.m.
Oh right, sorry. Well, my world clock is not is an hour out for you. Okay, so you're not on Eastern Standard. You're on Central.
Central.
Yeah. Okay. In which case, let's say we'll resume at 1:45 the hour, wherever you are. Mrs. Mankiewicz, one thing, by all means have a coffee and relax for 10 minutes, but do not speak to your attorney about your evidence while you're in the witness box. I know it's tempting, but please do not.
Oh, understand, and I also understand, Your Honor, that I'm still under oath.
You are indeed still under oath. Okay, so we'll resume at 1:45 the hour. Thanks.
Thank you.
We ready to proceed?
Yes.
Mr. Watson, your camera's not on.
Sorry, Your Honour, yes, I am here.
Okay. Can I just check that the court reporter is online? Yes.
Excuse me, can everyone hear me, and is my camera on?
Yes, you are coming through loud and clear and in glorious Technicolor.
Lovely, thank you.
Mr. Ivankovich, let's just have a look now at another email from the 19th of October, page 1121. You see this from an email from Harush to you. Do you recognise that email?
I do see this email, correct.
In your witness statement, you say that this email to you effectively came out of the blue, that there was no request by you. Do you recall saying that?
Yes.
And you don't respond to this email saying words to the effect of, I didn't ask for this, why are you sending me this information, this is all premature. Do you accept that?
If there's no response, there's no response.
I suggest to you that the reason why you sent me this message is because you had promised to make payment.
Your suggestion would be incorrect.
Let's now move on to later on in the chronology. On the 28th of June 2024, so the following summer, Mr. Moore asked for documentation on the yacht. You see this at page 1196. Oh, the bad page reference, I'm afraid. Excuse me, it's 1976. There we are. Mr. Moore asking for all documentation relating to the Aquila matter. And that email comes immediately after KGM sent through the final payment form. Do you remember receiving that? From the next page, I can refresh your memory, 1977.
Are you asking me, do I recall receiving this email?
Well, do you recall we haven't seen the onward sending to you, but do you recall discussing this email exchange with your lawyers? It's been brought to your attention.
Sitting here today, I do not recall specifically discussing these emails with Mr. Moore.
And I suggest to you that by late June, you were aware that Sino Eagle had given a final payment demand of 3rd of August. Do you accept that?
I'm sorry, so on what date?
By the end of June 2024.
If that's the date they gave the demand to KJM, then I can see that could be it. I don't recall a specific date around a final demand.
And the Sino Eagle letter itself is back at page 1281. So we've seen that to 26th of June, and then we've seen the project sent onwards by Mr. Radwan to Mr. Moore. And there's a clear statement by Aquila that if they don't receive the balance of payments by the 3rd of August, according to our purchase agreement, we will consider the paid deposit as a total loss. See that?
I do, yes.
And by total loss, I mean the deposit will be forfeited. Yes.
I believe Your Honor, it says we will consider the paid deposit as a total loss.
And I suggest to you, it's fair to understand from that email that Aquila was saying they will keep the deposit payment.
So perhaps I didn't catch it, Mr. Page. You're putting to the witness that he saw this document?
Yes, I'm putting to the witness that this document was shown to him by his lawyers.
By whom?
By his own lawyers. So this document was sent by Mr. Radwan to Mr. Moore. You can go back to that at 1977.
Yes. Now that's what's confusing me slightly. So let's just look at that. Mr. Radwan, 27th June. Please note, KGM received a notice of final payment from Aquila with a deadline 3rd August. As per records, Stephen paid 1.6, pursuant to letter from principal. Then what follows it is, what is that follows it?
So let's just go up if we ask EP operators to move up to something and see then the reply.
So that's page 1978.
The 19, so because how emails you read them from the bottom up. So it's 1977 is where the email chain starts, and you get the reply 1976.
Yeah, no, I know how you read emails. Can we go to 1978, please?
Oh, excuse me.
What is this? Do we know?
I'm afraid I'm not able to assist in court on that.
Okay. And then looking at going back to 1977. So then the response to that, the response to 1977.
Sorry, Your Honour. Just the text there looks to be It's the same actually as the piece of paper I've got for you. So
That's precisely why I asked you about it.
yes. So we have 1977 is the email. 1978 looks to be a screenshot, I think, from a phone, but that's me making an assumption here. 1974.
One 1974, yes.
We have the same text that is contained in 1978, but now we get all of the text rather than an extract from it. So this is an email from Philippa to Mr. Al-Jazmi.
Yes.
And we have there, it says there's an attachment, though the way in which these emails work, you don't see a sort of a trace of an attachment in text, but the attachment itself is at 1975.
But what I'm interested in now, if we go to 1976, it is the attorney's email. I request all the documentation to be assured that he is being dealt with fairly, warning him off from an effectual abuse. So it's your case that the letter from the yard was attached to the email that was sent to Mr. Ivankovich's attorneys.
Correct, 1977.
19.
So that it was attached to this this email.
Right. Okay. Okay. Just so I understand what the case is. I find attached here with copies of the email and the payment notice. So what do you say the email and the payment notice?
That is 1974 and 1975.
Okay. Right. Thank you.
So, Mr. Ivankovich, did you follow that exchange?
Did I follow that exchange?
Yes. Did you understand that the documents that Tom and I were discussing?
I do, although, Your Honor, I'm not an expert at emails, but generally, when there is an attachment to an email, there's like a little paper clip off to the right that would suggest there would be an attachment or a notation at the bottom. This email doesn't show that, so I'm a little dubious that there was anything attached to this email from Mr. Radwan's, but I don't, these emails are not addressed to me, and I don't recall seeing them, so I can't comment on them other than what's written in them.
But I think where this is leading to, without anticipating too much, is that the documents at 1974 and 1975 were sent to your attorney, and your attorney would obviously have shown them to you.
To be truthful, Your Honor, I don't recall seeing the document from the shipyard. I do recall having a discussion of that nature with Michael Moore, that the shipyard might be canceling the transaction with KJM, which, on my recollection, why we requested repeatedly copies of the contract, or to be in communication directly with the shipyard to understand their position, but we were not afforded that luxury.
So, Mr. Rankovich, as you say there, the tenor of these communications at 1976 is looking for information from the shipyard. There's no direct statement here that of words to the effect that Mr. Rankovich has been asking for copies of the survey for months or even a year now and hasn't provided. You accept that no one here is still talking about non-receipt of the survey.
I don't see that mentioned in this email. That's correct.
Your evidence is that the survey was first received on the 11th of July 2024. Do you accept that? Or do you recall that?
That is correct.
According to the chronology we're already looking at, by the time you saw the report on the 11th of July, you already knew the transaction was at risk. Do you accept that?
Well, we do know that that was the information being conveyed to us. We had no direct knowledge of that.
Well, as I say, I've already shown you the documents showing that the communications from the yard were provided to Mr. Moore.
Well, you have shown me those documents, yes, Your Honor. Again, without having direct communication or direct knowledge with the factory, it's tough for me to comment how those documents came to be.
Then, in terms of the report itself, let's pick up the trail of page 1291, please. Actually, it's not quite in chronological order. 1289. So 1289 is the 5th of July. So we're here, we have dialogue about whether Moore and Co can be in charge of possession, ownership, and title upon delivery. See that?
I'm sorry, sir. Your comment was a little muffled. Can you please repeat that?
I'm sorry. So can you see in front of you on the screen? It's an email of 5th of July 2024 from Mr. Moore to Mr. Radwan. So your lawyers, or Contessa's lawyers, and Mr. Radwan being KJM's lawyer, and they're talking about the logistics and legalities of transferring ownership and wanting Moore and Co to be in charge of that process. You said that's what's being asked for there.
I do see that, yes.
And if we go up a page to 1288. Towards the middle of the page, Mr. Radwan replies to say, yes, that's fine. Moore and Co can be in charge of the procedural aspects of the yacht at point of delivery. All they want is a POA, power of attorney. And then it would be registered under your name. You see that?
I do.
You'd accept it that KJM, through Mr. Radwan, is being constructive and facilitative, trying to help this sale finalise, please.
Your Honor, I do accept that that's what this email says, but later in time, it is my understanding they rescinded that structure and would not allow us to take possession or ownership of the boat directly.
And let's look at the rest of this email. The next paragraph starts, kindly note that Mr. Al-Jazmi has communicated on multiple occasions the yacht report, uploaded on the link, we provide a link. And if we turn over the page, pursuant to the loan agreement, please note that the shipping of the yacht to UAE is pending the fulfillment of the remainder balance with an amount of 2.39 million by Stephen. considering the notice period, we would appreciate letting us know the final decision, as after the notice due date, i.e. 3rd of August 2024, the factory will execute on the deposit. So you see there in that email that Mr. Radwan is passing on the documents and is saying that these have been provided to you on multiple occasions previously. See, that's what he's saying?
That is what it is written in the email, correct?
And I suggest to you that that email is accurate and that you had previously been provided with the report.
Your Honor, I don't accept the premise of the email being entirely accurate.
To accept that KJM had no reason to hold back the report.
I do accept, Your Honor, that they had no reason to hold back a report once it was finished.
Let's have a look at page 1309. And again, the email chain, let's pick it up. Here, let's pick it up the emails from 1313 at the bottom, please. This then is an email from Mr. Radwan, 22nd of July. Again, a warning is being provided that the deposit will be forfeited. It's a non-fulfillment of the due contractual obligation, i.e. paying the remainder balance. See that?
Yes, I do see that.
And then Casey Flitman replies, and this is emails over 1312 to 1313. And it seems there that she's just trying to access the link. So no one has downloaded the documents between the 11th and the 22nd of July. That's a fair assumption, correct? Fair inference.
I'm sorry, sir. When you face downward and don't speak into your camera, your audio is garbled. If you can, when you speak, if you can look forward and speak in the mic, it'd be very helpful.
So yes, I was going to say that too, actually, and indeed the court reporter has marked a few parts of the evidence inaudible.
Yes, I've now just seen that the microphone was the camera rather than my AirPods. So I've changed that over. Hopefully that now should be better.
It sounds better. You sounded
Incredibly
like you're
better.
underwater.
Thank you,
before.
sir.
Oh, thank you. My apology. I wasn't aware of that, and I'm working for a paper copy, hence why I'm not always looking upwards at you, Mr. Ivankovich. There's no discourtesy intended, I assure you.
I don't blame you for not wanting to look at me all the time.
So, the 22nd of July email from Casey Flitman. It says there that on her first line, the link you sent us is expired. Do you see that?
Yes, I do.
And it looks like that nobody had downloaded the documents between, or nobody had attempted to download the documents between the 11th and the 22nd of July. Do you accept that?
It's impossible for me to draw that inference from this email, Your Honor.
Well, what we have, let's contrast page 1288. So Mr. Moore's reply is, this is not sufficient. So it looks like he had looked at the document on the 11th of July. To accept that, that's presumably why he's saying it's not sufficient. He's looked at the document itself.
Your Honor, can we please ask the operator to scroll up, because I'm not entirely sure what that's a reference to.
Let's not scroll up, let's scroll down, because we'll then
I'm sorry,
get
scroll down, yes.
So we've looked at this email already, Mr. Ivankovich, and this is, I've just read out all of the text in this email with the WeTransfer link that refers to the yacht reports. And then Mr. Moore's reply is simply, this is not sufficient. And I'm suggesting to you that the word this there is a reference to the document he has found behind that link.
I accept that could be a reasonable assumption.
Your Honour,
Your
Honour, I hate to interrupt my learned friend's cross-examination. I'm not sure the premise of his question is correct, because at 1287, one can see the original 11th of July email that is sent by Mr. Radwan to Mr. Moore, and one can see that what I assume is the Admiral report is actually attached as an attachment. And then there is a link with two files, which presumably are the corrective action document and the letter from the shipyard, because Casey Flitman refers to them being sent 3 documents. I'm not sure my learned friend has established that the Admiral report is on the link as opposed to just being a bare attachment to the email.
With respect, I don't think anything turns on precisely the form in which the document was attached. But we have here it's clear the report is being attached, whether it's 1287 or 1288. We then have Casey Flitman's reply on 1312, 10 days later, saying that the link has expired. Do you see that, Mr. Ivankovich?
I do, yes.
So whatever is behind the link has not been accessed and saved. Do you accept that?
Well, I accept that Ms. Flitman doesn't have access to it, Your Honor. I don't know to the extent of documents being shared between Mr. Moore and Ms. Flitman. But it's clear from this email, Your Honor, that Ms. Flitman is having trouble accessing those documents.
So we have a situation in July 2024 where everyone knows now that the yacht is about to be forfeited, or the deposit will be forfeited. And we have a 9-day gap where it seems at best you're saying no one was communicating with each other on your side of the fence. Is that a fair inference to draw?
No, I believe our communication was very clear in terms of what was expected from Mr. El-Jasmi and Mr. Radwan.
So Miss Flitman then says at 1309, we only, do you see this email? We only received 3 documents. These documents are not satisfactory. And she lists those there, and they are the outstanding payment demand, the factory corrections actions report, and the pre-delivery condition survey. You see all of that?
I do.
And she's saying they're not satisfactory, and she's asking for a range of other documents. You see that?
I do.
Now, by the 30th of July, which we can see on 1305, there is discussion here of payment, of wiring the balance of the monies directly to Sino Eagle. You see that, 30th of July, 1305? Would you be good enough to send us the wire instructions for transfer? That's what Mr. Moore writes.
That's correct. That is what is written.
So by this point, you were prepared to proceed with the transactions?
Under the circumstances that Mr. more outlined, correct.
So despite your evidence that the Admiral report was not satisfactory, by the end of July 2024, you were content to, or you were prepared to proceed, put it that way.
I was considering proceeding under the structure which Mr. Morris suggested, that was rejected.
Well, and the structure now is that you would become the owner of the vessel. Yes?
Not me individually, but a vehicle, I believe the structure that was contemplated would be a special purpose company to take ownership of the vessel.
Well, we can see here at the bottom of the page, what was communicated was that the buyer would be Stephen Ivankovich or Assigns. You see that?
Correct.
And then Mr. Radwan replies towards the top of this page. Please find the pro forma invoice with the wire details of both KJM and the builder. And talks about how the contract works. Saying nonetheless, if it would like to have the yacht under the name of Stephen, kindly direct the purchase to the factory, either Sun or Eagle, and KJM will process all documentation under the name of Contessa Marine or Stephen. In either option, please note that the transfer process should consider that the factory should receive the remainder balance before the due date. And why was he saying that before the due date?
I don't know, other than there seems to be implied that there was a date expressed that a deposit would be forfeited. Would be forfeited, Your Honor, on that date.
So standing back then, many of your dealings have been in person through the past year, and you told us earlier that you went to Dubai about once per month. Is that right?
I wouldn't categorize that way, but I frequented Dubai.
And you said when you were in Dubai, you tried to visit the factory every day. Is that right?
Yes, that is correct.
So this is a relationship where we know that you saw Mr. Al-Jazmi at least 5 times in July and August 2023, yes?
If I was in Dubai, I would see Mr. Al-Jazmi.
And we also know, and we'll come to look at this later on today, that there were 6 meetings in person before the joint venture agreement was executed. Does that ring a bell to you?
Your Honor, which are you saying the joint venture agreement between myself and KJI?
Well, between you and KJM, but yeah, involved in the creation of KJI. In February and March 2023, we know that there are a number of in-person meetings between you and Mr. Al-Jazmi. Do you recall that?
Yes, there was definitely in-person meetings prior to the formation of the joint venture.
And in September 2023, we know there were further in-person meetings. Do you recall those?
I do, yes.
And let's just see a digital fragment of one of those meetings. Page, I think my reference might be here, might be 1298. That might not be right.
Before you leave that page, the last page that I looked at was 1305. And there were attachments to the email from Mr. Radwan. Are those attachments in the record? Just for my note.
I haven't been able to spot them so far, Your Honour, but I may be told where they are.
Okay.
I think, Your Honour, the attachment is at page 1320. It's because it's a very long chain. One has to go all the way down.
Let's have a look.
Well, that's one of the documents because it refers to also documents from Sino Eagle as well.
Well, it does have Aquila bank details. Which
Yes, I've now seen this bottom right hand corner.
Yes. Okay. All right. That may well be the document. Thank you very much. Sorry to interrupt.
So the meeting's in September 2023. Let's turn to page 1298, please. Oh, no, well, that isn't right. So let's have another look at. Let's try 1928. See if it's there. Yes, so we have there a reference to, didn't go over this in person, and that's a reference to meetings that have happened in or around September, October. And you see there on the line 2, when we were all in Dubai a few weeks ago, so that's suggesting that there had been a meeting in September. Do you accept that?
Yes, I do accept that. It seems that Nathan, Oli, and I were in Dubai a few weeks ago from the date of this email.
And there had also been a meeting on the 12th of October. And one of those attachments there, the notes on the KJI AF 250, we can see that the notes themselves are at page 1927. So it looks like there was another meeting on that date. We know there's also looks to have been meetings in November. If we go back to the email we were in, excuse me, no, the Americanization of those dates, 1928 again.
Sorry, 1927.
So
What vessel is that about?
As a different vessel, Your Honour.
Yes. Which one?
But that's an arrow, which is part of the KJI. KJI manufacturing process. So what this shows, we're having meetings in September. This is an October meeting. It looks like you weren't at that meeting, because if we go back to 1928.
Your Honor, that meeting was not about the arrow. The AF 250 is specifically a 25-foot rigid inflatable boat that we had brought over to contemplate the manufacture and sales of from KJI.
If we look at 1928, you'll see there one of the attachments was going to be items to discuss with you on the 11th of October. You see that?
Well, I see that the title of that, Your Honor, is items to discuss with Steve, and the date, but it's unclear is if that's the date of the document rather than specifically the date in which they would discuss it with me.
That's a fair response. Very careful, if I may say so, Mr. Ivankovich. I suspect this isn't the first time you've given evidence. Is that right?
This isn't the first time I've given evidence, and I appreciate the specificity of language, Your Honor.
So what we do learn here at 1928 is that there looks to be items to discuss with you, and the broad point I take from this is that those discussions would have been in person with you in or around October 2023 during a visit by you to Dubai. Is that correct?
No, not necessarily. Nathan Greenwood's offices were in Traverse City, Michigan, and Ollie and I met with Mr. Greenwood specifically on the aquaform topic, and these vessels in Traverse City. So I don't recall meeting with Mr. Greenwood and Mr. Hand in Dubai to discuss the aquaform boats, but I do specifically remember meetings with them in Traverse City, Michigan.
And we learn at 1944, this is an email from Mr. Greenwood to you and Mr. Hand, that he's been travelling to Dubai every month. We see this from the fourth line down. This is the main reason I continue to travel there on a monthly basis. Albeit he's talking about a different issue here, but he's going to Dubai regularly. You see that?
Yes, I do.
And let's look at 1951. This is an email from Chuck, Captain Chuck Trapp. He's a man who works for you in some capacity. Is that right?
Not for me directly, but he does work for one of the family office companies.
And again, he's there sending you an internal email explaining that he spent a lot of time. He was, his most recent trip, he was speaking to Parouche, and spent a lot of time discussing, documenting various different ideas and notes. So except that he was also traveling to Dubai regularly and meeting with Parouche and meeting with Mr. Al-Jazmi.
That is correct. And as a family office, we were underwriting that travel.
Page 1962. Let's just pause here and do this email a bit more slowly. So this is an email from you to Mr. Al-Jazmi, 6th of March 2024. Do you see that?
I do.
And the final bullet point in this email, it looks like here, like you are responding. I think the black text in bold is a message from Mr. Al-Jazmi, and you are replying to that. So he's asking for the transfer date of Aquila 70. Let me just explain why I'm putting that to you, Mr. Ivankovich. If you go again to the top of this email, you see it starts comments below.
Yes.
And we can see in the subject line, aquaform, and that suggests that there has been an earlier email to which this is a reply. So again, let's go to the bottom of the email chain, and I read it as the bold text being from Mr. Al-Jazmi, but tell me if you disagree on that.
No, that is correct.
And then your comment is in the normal font underneath it. And you're saying there that you're waiting for liquidation on certain securities to free up this capital. That's to be able to pay for the Aquila 70, you're waiting for the liquidation of certain other assets. Is that right?
That's what is written, correct.
And as you know, the delay in selling the Sunseeker created an unforeseen negative delta in our equity position. I will know more this week. So you're there explaining to Mr. Al-Jazmi that because you haven't sold the Sunseeker, you don't have the cash available to purchase the Aquila. Was that a fair reading of that email?
Your Honor, just to clarify the point, I believe Counselor said misquoted and said equity position rather than liquidity position, if I heard that correctly.
So you're quite right that the transcript says equity, but I intended to say, maybe others heard it differently, liquidity.
That's correct.
So let's just get this clear for the transcript. You were here in this email linking the sale of the Sunseeker to the purchase of the Aquila 70. Is that correct?
No, that's not what I'm doing at all. I'm simply making a statement that, and also coyly reminding Mr. Al-Jasmi that they failed to meet their undertaking to sell the Sunseeker. And we have to sell more securities to have cash available to complete the purchase of the Aquila.
You finished the email by saying, see you tomorrow. So that suggests that you were going to be in Dubai the next day. Is that right?
It would suggest that, yes.
So I suggest to you that the report was handed to you in Dubai. And do you accept that?
I do not.
And that it was handed to you in July 2023 and at the latest by September 2023. Do you accept that?
Your Honor, I don't accept it. I find it remarkable that of the hundreds of documents that were exclusively passed to us electronically, that this one magic document, that there's no evidence of being transferred or sent to Mr. Al-Jasmi, is somehow the only document in the world of documents that was given to me in person. And in the event that it was, I would have asked for a copy to be electronically transmitted to me and to Mr. Hand. So I don't accept that and find it remarkable that this one single document is the only document of this nature or of any nature that was not transmitted to me electronically.
So, Mr. Rankovic, you've already given your evidence and you've made this point in your evidence, and this is not time for little speeches. So just confine yourself to answering my question, if you can, please. I suggest to you that you read the document when it was handed to you. Do you accept that?
The document was never handed to me.
Alternatively, I suggest that you chose not to read it when it was provided to you. Do you accept that?
It's very difficult to read a document that isn't handed to you.
On either basis, you treated the report when you received it as satisfactory. Do you accept that?
I do not accept it.
And I suggest to you that you're wrong to say that you were never given a copy of the document by hand. Do you accept that?
That, Your Honor, I do not accept that. That is just a patent bald-faced lie. The document was never handed to me in person.
Is it correct to say that you never commissioned your own survey of the vessel?
We weren't afforded the ability to. Mr. Jan Thorvassen was blocked, along with Mr. Hand, from being able to go inspect the vessel.
And that even when it's agreed you had seen the report in July 2024, you raised no issues about the quality of the vessel at that time. There was no reference to the snagging list. You accept that?
Well, I didn't, but that wouldn't have been my responsibility to do so. We have a team for that of experts.
And the reason is that no one had an issue with the snag list, did they?
Your Honor, that's clearly not true, given the body of evidence.
Well, at the time, there was nobody ever said that the air conditioning unit and the comments about that were your reason for not paying. That's right, isn't it?
The report was unsatisfactory.
The air conditioning unit was a matter that would just be serviced on delivery, like any other new vessel. That's right, isn't it?
No, again, Your Honor, this is why a physical inspection after a survey report is so critical, because we would have known, number one, if the air conditioning units were substandard, defective, miswired, if they were not functioning because of there would have been a fault in the way they were plumbed. That's why physical inspections to corroborate survey reports is critical.
Let's move on. So now I'm just going to look at again some of the dialogue in the winter of 2023. Mr. Al-Jazmi's evidence, if we take you through to that, please. Page 95 of the bundle. Paragraph 43, bottom of this page. You see there that he states that in September 2023, he passed on to an approach he had to sell onwards a vessel for $4.5 million. Do you recall that? He told you that information?
Your Honor, what I do recall was numerous queries from Mr. Al-Jasmi that there were people interested in purchasing the vessel subject to a leasing program, which we had discussed.
And he reports that you wanted to proceed as originally envisaged. You see that at the top of page 96. And that evidence is correct, isn't it, what he says there?
I really don't understand what that statement means, Your Honor. But did I want to proceed on the purchase of the Aquila under the terms of our agreement? Yes, we tend to honor our agreements.
And let's have a look at page 1107. We've looked at this exchange already, but the 5th of October exchange, it all picks up on the earlier dialogue. So by then we know that $4.5 million is too low a price to you. So and you're playing a different concept here. This is the lease concept. That's right, isn't it?
No, not at all. The discussion was with Mr. Al-Jasmi that the boat would be much more marketable and attractive to sellers, and the sellers that he was talking to had expressed interest in purchasing the vessel under a contemplated lease or financing package.
And that package, we've seen it. Let's have a look again at 1109. It's what an English would say is the back of a fag packet calculation. But broadly speaking, this shows the value to you of the vessel is about $5.5 million. Do you accept that?
No, I do not. That would have been the sales price and the benefit to the venture, not just to me exclusively. It was I am familiar with the term, Your Honor, back of the fag pack. It was a pro
Not
forma.
an expression I would use where the American witness was involved, but there we go.
Point taken, Your Honor, but I am comfortable with that. This was a pro forma example, and again, in simple commerce, when somebody pays for cash, they are focused on the ultimate price they're paying. When somebody is financing a car or a boat or even a home, they're focused on the monthly payment. So the logical and rational business decision is, if someone is asking you to finance the purchase of a product, they don't have much negotiating power in the purchase price. And in fact, what they are focused on is the monthly payment. That's all this is. This is an example of how a lease with a residual value would work.
let's look on at another exchange from November. It's page 1144. So it's you here are the writer in white, and I think it's Parouche who's the writer in green, or Mr. Jasmine maybe. I don't know which. So, but the person on the KGM side of the fence is talking about loss of response and also favourably for the Aquila 70. How can we proceed with the matters of the 70 in the factory? Even the factory guys would like to have that boat completely paid up and moved out soon. And your response is, we have to send them a wire. So that's a statement by you that you need to make payment to that. Do you accept that?
Well, Your Honor, if you've noticed sometimes from my demeanor and responses, I tend to be cheeky. This response is a cheeky in the British colloquial response to Mr. Parouche's comment, how do we proceed with the matters of the factory? Well, obviously send him a wire. The second, which underscores that point, Your Honor.
Well, let's just pause there, Mr. Vankovich.
Where I write,
Mr. Vankovich,
shall I have it shipped to the US as well? That is my veiled sort of jab at Mr. Hyderabadwala about the Sunseeker, because this same structure of the Sunseeker, where I make a deposit, it would be delivered and sold to a buyer in Dubai, was promised to me. It did not happen. We ended up pivoting and having to take delivery of that boat to the US. So this is my not so veiled jab saying, well, if we have to pay for the Aquila, are we going to have to not have a buyer in Dubai as well and ship it to the US? That's what this exchange is about.
So, Mr. Vankovich, I'd like to just confine you to my questions, please, rather than giving little speeches. Your response there's nothing sarcastic on the face of that response, is there? You were not being sarcastic.
I've just explained my sarcasm.
And there's no other instance of you being sarcastic in messages, is there?
Pardon me?
There's no other instance of you being sarcastic in messages that we've seen.
Your Honor, I'm sure if we cull through the nature of all of our correspondence, we could find many instances.
In fact, what's happening here is there is a straightforward question about what are you going to do with it, and a straightforward answer. You're saying to him, we're going to send them a wire. We have to send them a wire, and that's correct, isn't it? That's factually correct.
That is the logical question response, Your Honor, to how do you proceed with the factory?
And
in Your Honor, I will notice again with my precision of language, it does not say we shall have to send them a wire. We have to.
Okay.
If you want to complete the transaction, not saying that I've undertaken that.
So, Mr. Ivankovich, with your precision of language, you have no comment here about the survey. From your perspective, you knew the survey had happened 5 months earlier. On your case, the survey hadn't been given to you yet. You must have known that it would have been produced by now. But you're not asking for it, are you?
If the survey was completed, it would have been given to us. It had not been.
Well, Mr. Ivankovich, we know that the survey was completed. We know it's completed on the 10th of July. So you said it was given to you.
Your Honor, I'm very dubious about that fact. One portion of the survey that really stood out, and I am no computer technician, but when we received the survey electronically in July 2024, we did a quick metadata check on when the document was created. And the metadata showed that the document was created, in fact, in July of 2024. So immediately our antenna were up as to when this was created.
Well, Mr. Vankovich, it's been no part of your case to have the digital trail of this document forensically examined. everyone accepts that it is a fair survey of the vessel in July 2023.
We accept that's what it said. And the document was received in 2024.
It would be bizarre. So are you saying, in fact, you think the survey was created in July 2024?
Given the conduct and history of Mr. El-Jasmi and his team, it would not surprise me if that would be the case.
So if it was created in July 2024, you're saying that the survey sets out the condition of the vessel as at July 2024?
It's very possible. It's hard to understand, again, because we had no direct communication with the surveyor. We did not visit the boat with him. If and when, in fact, he did tour the boat, and how close an inspection he did.
Before we move on from this page, we can see at the bottom that Mr. Perouche, at the time, he understood your comment, your, as you say, sarcastic comment, not to be sarcastic. That he simply replies, we need the 70 in this region. You see that?
I do see that.
So, in fact, he understood you to be saying, you'll have to send him a wire, and I disagree. Let's not get it shipped to the US. Let's get it shipped into Dubai, because KJM is confident that it could sell it for a profit.
And, Your Honor, those are the same comments and undertaking Perouche and Mohammed made to me before I completed the purchase of the Sunseeker.
Let's move on to another set of documents, but I'm just...
I'm sorry, if you're going to leave this set of documents,
yes,
then can we please
page,
go
yes,
to page 1145?
That was where I was going next, Your Honour.
Okay. You're going to go there and then 1146?
Yes.
Okay, in that case, I won't ask the question I wanted to ask.
Well, I'll perhaps if I be fair, maybe if I put the questions in, if I've missed anything, Your Honour, I'm sure you'll come in with any questions you have.
Yes.
So we have here in the exchange of the 30th of November at 1145, this is 2 weeks later, Perouche is pleading with you to make payment, isn't he? Please help. You see that?
I do.
And again, there's nothing sarcastic in the face of on the face of any of his comments, is there? He just really wants you to make payment.
I'm sure he does, Your Honor.
And then we see your reply on 1146. You're commenting on other points initially, and then you deal with the Aquila 70 at the bottom of 1146. And you say there, it is as far as the balance, as far as balance of the payments for the 70 Aquila, it is already set up and will go in order of the others. I will let you know when.
That is correct.
The meaning of your words is you are promising to make payment, aren't you?
That is incorrect.
There is
Your Honor, that's why we have contracts. It actually just goes to show, and contrary to the previous line of questioning, that we do have the funds are set up if the obligations of the contract are fulfilled.
There's no suggestion here that you are waiting for any other documents. You agree with that?
I think it does suggest that.
So you're saying there is some reference here to the survey?
No, I'm saying there is reference to procedure.
But I suggest to you there's nothing here to say that you are holding back money, you're waiting for any documents, simply that you are promising you will make payment.
Your Honor, I don't understand how having a wire set up and ready to go is a promise of making payment. The payment would have been made had the contract been honored.
Your Honour, did you have any questions on these 2 pages?
No, it's just when you said you were leaving the set of documents, I thought you were leaving the WhatsApps entirely, that's all.
No, it was just that particular date. I'm now moving on to the 4th of December. There's 1158. And so we have some more WhatsApps here. So the first set of messages are about the 100. So that's a Sunseeker. Is that correct?
Yes, that is correct.
And there's no mention. So it's Parouche who's speaking in the white boxes and you're in the green boxes. Is that right?
That seems to be correct. Yes.
Yes. So Parouche is talking about the Sunseeker 100. And then let's just carry on the chain, please. 1159. And then again, talking about a Nissan car, I assume. And let's turn over the next page. And talk about trains. See nothing there about the Aquila 70. You agree with that?
Correct.
And then the turn over to 1161. And now we get a reference to the Aquila 70 towards the bottom of this page. You see that?
Yes.
So to accept that you are the person who raises the Aquila 70 in this dialogue on the 4th of December.
Yes, it seems to be the same text chain from a different perspective as the previous one.
Well, it's a different date. And the reason you had raised the Aquila is that you and Parouche had been speaking as well, hadn't you, about the Aquila?
I'm sorry, my learned friend just suggested that this. I think my learned friend just suggested that this was a second message, a repeated message, but it's clearly the same message, just from a different perspective as the message at 1146.
Yes, correct.
It's just that in the other chain, all the intervening messages were left out.
Not there. Okay. Well, so we have this message. So we can see here this message. You are raising the 70 Aquila yourself, yes?
That is my text message, correct.
Well, maybe the time difference is at fault. One's 11:52 and one's 2:52. It's
well, they're different phones, Your Honour, aren't they? So one would be set to one time zone and the other would be set to the other.
yes.
But so, Mr. Vankovic, what's important here is the reason why you raise the 70 Aquila there. And the reason why you raised the 70 Aquila in this conversation is because you were being pressed for payment. That's right, isn't it?
I don't think you can infer that at all from this text chain.
And you were there giving Parouche an assurance that you had already taken steps for payment to be made.
Yes, and as I did in the previous email, that we need to raise liquidity to do it. So correct.
So you accept you could have said here, what about the survey? I haven't seen it yet, but you're not saying that.
I accept I could have said a lot of things.
And Parouche's response is, okay, thank you. Do you see that?
Yes.
So you accept that he believes you. He believes you've got to make payment.
I accept that he believes the payment was set up.
And again, let's have another look at a message we've seen previously, page 1201. And this is the email. We've looked at this bullet points as well. And I think, in case I haven't suggested this to you already, that here you explain that the reason for non-payment up to that point is due to a lack of liquidity, not the lack of a survey. Do you accept that?
I do not accept that, Your Honor. That's not what this says at all.
Let's then move on to the 21st of April, 2024, with page 1250. If we look towards the bottom of that page, we have there an email from Mr. Al Jazmi. He there is talking about the Aquila 70 matter, talking about extraordinarily delayed and concerned about your deposit. And there was a deadline it passing on to for payment of 28th of April. You see that?
I do see that.
And he's saying if you don't pay by this date, the factory will take the deposit. Except that's what he's saying.
That is what is written, correct.
And then your reply, back on page 1250. I think actually we get the full replies at page 12. It starts at 1252. We only get a fragment on that page. 1252, please. So towards the bottom of that page. Thank you, Mo. The replies help me draft a reply. And then you deal with Aquila over the page. It's also critical that you reply to Casey and Ollie with information requests about the Aquila purchase. And then you say at the bottom, a loss of deposit, end of that paragraph, a loss of deposit will be a loss for the JV as specified under the JV document. You see all that?
Yes.
So there's no reference in your email to surveys. Accept that?
I don't. I think it's plain as day, Your Honor, where it says it's critical that you reply to Casey and Ollie with information request about the Aquila purchase.
And the email exchange from Casey and Ollie on that's at page 1968, 1969. Let's look at 1968 first of all.
Sorry, just Mr. Vankovich, you said it's critical. You reply, I'm sorry, where's that wording? Or is that a comment?
I was reading the sentence. If you want to go back, I can reread the sentence and that.
Yes, just so I can highlight the sentence on the document.
1253, Your Honour.
Yes. I just
It is also
sentence.
critical that you reply to Casey and Ollie with information requests about the Aquila purchase.
It's the first it's the first line of that paragraph. Sorry, I was looking at the end of the paragraph. Thank you so much.
You're welcome, Your Honor.
So the requests about the document, the requests from Casey and Ollie, we'll see those now. First of all, 1968. So there's no express reference there to the survey. You accept that?
I do accept that the lawyer who's not responsible for the survey is not requesting the survey.
So what they are looking for here is information upstream between KJM and Sino Eagle. And there's no reference to the condition of the yacht. You accept that?
In this email, there is not, correct.
And then we have the chasing email from Ollie Hands, 1969. And again, no reference there to the survey either. You see that?
That is correct.
And so in reality, the issue here was not about the yacht condition. The concern was whether or not KJM had made a secret profit by paying a smaller sum to Sino Eagle. That's right, isn't it?
Your Honor, I disagree with the categorization of that. Mr. Hand specifically says she needed all paperwork and information. And all paperwork and information certainly includes all the condition reports of the boat, including the survey.
Let's move on to June 2024. We have we've already looked at this document 1281. And you'll recall the exchange we've had about this document and this information being passed on to you. So by this point, everyone now is being told about the 3rd of August deadline. And you recall that?
Your Honor, I disagree with the categorization that if it's being insinuated that when it is stated this information was passed to me, that this letter was passed to me, I do not recall.
No. Mr. Ankovich, I'm being careful about my language, and there is no trick question in what I'm asking you here. The information was passed on to you.
And Your Honor, can I please inquire as to what specific information he's referring to?
The 3rd of August 2024 deadline, Mr. Ankovich.
It's possible at the time. Again, I don't recall that date being a magic date, but it was.
Okay.
It could have been.
Well, we need not go through it, but the references are 1282, where as an email from Mr. Jasmy to Mr. Radwan, passing on the information. We've looked at Mr. Radwan to Mr. Moore, and that's 1973. And we have the 3rd of August date there being given to your lawyer or Contessa's lawyer. Do you accept that KJM paid money to Sino Eagle to keep to hold open the deal for you through 2023 and 2024?
Your Honor, I do accept it, and it's always been puzzling to me after I learned of the nature of the payments, of why the full $1.6 million wasn't transferred as a deposit to the company. I accept that money was transferred to Sino Eagle based on the evidence provided, but I scratch my head on why the $1.6 million wasn't transferred. In fact, and it's hard for us to comment because we've never seen a copy of the contract. But there were monies transferred. It wasn't the $1.6 million, which is puzzling to me.
So, Mr. Rankovich, I just want to give you a choice here. So I think you were listening in on the call yesterday with the judge, and I took him through the bank statement. Would you like me to take you through the bank statement so you can comment on them, or are you content that they do show transfers to Sino Eagle with the reference of Quilla?
No, Your Honor, I certainly would like to go through those transfers because I think they're very telling on what's going on here.
Well, we're going to do that after the Dubai lunch break. And also an opportunity for you, Mr. Vankovich, to get some early breakfast at 5 a.m. So we're going to have to break now until Dubai will be 3 p.m. London will be midday, and it will be 6 a.m. then for you, Mr. Vankovich, in Chicago. Again, I know you're aware, I just need to underline it each time. Please do not speak to anybody about your witness evidence whilst you're in the box. Okay?
Absolutely, Your Honor. Thank you.
Okay, well, we'll resume in 1 hour. Thank you. Are we ready to proceed?
Good afternoon, Mr. Vankovich.
Yes, that's okay. The transcript is running. Good. No, please proceed.
Good morning.
Thank you. Good morning again. Slightly later in the morning for you. Mr. Vankovich, we were just about to look at some bank statements. What I don't want from you now is a series of comments and arguments. Those are going to be for your barrister to give later. I'm just going to put through to you a number of questions about whether or not you accept payments were made or not. So let's have a look at page 1627, first of all, please. Do you see this is an account statement in the name of KJM Marine?
Yes.
And if we look towards the bottom of this page, we have a series of payments out. They're all debits. Do you agree with that?
Yes.
The final row shows a payment out to Sino Eagle Yacht. Do you see that?
Yes.
and it finishes with the word Aquila. Do you see that?
Yes.
This, we see in this row that the payment is for $1 million. You see that?
Well,
it's in the.
It seems to
Let
be
me
in
just tell you
Durham.
where it is. So in fact, in the narration column,
Yes, I see it now, Counselor. Thank you.
it says USD $1 million. And so we can ignore the precise numbers in dirham. It's the US dollar figures I'm interested in.
Understood. Thank you.
So do you accept here that we have a payment from KGM to Aquila of $1 million?
Well, to Sino Eagle, yes.
I'm so sorry, to Sino Eagle, yes. And that payment is referenced for the Aquila.
Well, it's referenced Aquila. I don't accept that it's referenced to the Aquila 70 because the Aquila is the brand name for a boat. It could be any Aquila.
So to your knowledge, was there any other purchase being made on the 30th of May for a different Aquila vessel?
Not to my knowledge, but to my knowledge, Mr. Al-Jasmi was posting on his WhatsApp line pictures of numerous different Aquila boats for sale. That is what I know.
Okay, so all I'm going to ask you about what it is you know and what you can tell from this, and you'll get to the end of your knowledge and you can say, I don't know at that point. So we have the 3 rows above this payment, and these all look to be telegraphic charges and associated charges from the bank. Do you see that?
I do.
So it doesn't look like anything there is going to Sino Eagle. Do you agree there?
Correct.
Let's turn over then to 1629. Here again, we have a bank statement in the account name of KJM Marine. Do you see that?
I do.
And at the bottom of this page, we have the table of payments again. The 2 payments on this page, again, you see they're reference Aquila, but the payee is not Sino Eagle. You see that?
I do.
Then over the page, we have at the top there, the payee is Sino Eagle. Do you see that?
I do.
And the payment to them is $907. You see that?
I do.
And again, the payment reference is Aquila. You see that?
Spelled different than the other one, but yes.
Yes. In fact, if anything, this one is spelled accurately, isn't it?
I actually am not sure, but I do know it's spelled differently than the other one.
So far as you know, as of the 7th of August, is there any other Aquila vessel being purchased on this date?
Because I've never seen the contract, I honestly don't know if any Aquila vessel is being purchased.
Let's move on then to page 1631. Again, this is an account in the name of KJN Marine. Do you see that?
I do.
And then again, at the bottom of the page, we have the same pattern of we have bank charge payments, reference Aquila. We now have a 3rd spelling of Aquila. We now have double L.
That is correct, Your Honor, a 3rd spelling.
And over the page, we have 2 further payments. Again, the top one is a bank charge, and the bottom one is a payment to Sino Eagle. Do you see that?
I do. That is correct.
And again, this payment, are you aware of any other Aquila vessel being purchased other than the Aquila 70 that's the subject of our claim?
Your Honor, I'm not aware of the information I have any Aquila vessel being purchased.
Let's look on then to the next bank statement. 1633 is where it starts. And again, we see the account name is KJN Marine. That's just at the top there. Is that right? You agree with that?
Yes.
And over the page, we see the payment transfers. And all of these happen on the 20th of November. Do you see that? If we scroll down just a little bit.
I do, yes.
And the top 3 rows where we can see the text, these are various different bank charges. Yes?
Yes.
And we're now at, let's call it spelling number 3 for Aquila for those. And
Yes.
those charges look to be associated with a transfer that's row number 4 for $50,000 to Sino Eagle. Do you see that?
Yes.
And again, that says Aquila is the reference. You see that?
I do.
And it's the same question again. Are you aware of any other Aquila vessel being purchased on the 20th of November other than the Aquila 70?
My testimony again is I'm not aware of any Aquila being purchased because I've never seen a purchase contract.
But you put it a different way. You're not aware that it's in you don't know that it's in respect of any other Aquila vessel other than the one that you are associated with, the Aquila 70.
I do recall during that time period, Mr. Al-Jasmi told me that he was working on the sale of a 44 Aquila. That's the only other Aquila sale I know about.
Well, that is a mention in your evidence, Mr. Ivankovich. But let's move on to the next payment on the same date. You see the next 3 rows. Again, you see banking charges, and the final row, you'll see in the narration column, it's a payment of $145,000 and $8. Do you see that?
That is correct.
And again, the payee there is Sino Eagle, you see?
Yes.
The payment reference is Aquila.
Yes.
And I just see that again is linked to the purchase of the Aquila vessel that's the subject of these proceedings. Do you agree with that?
I do not agree with that comment implicitly.
And that's because your full answer to that question would be, I don't know. Is that right?
I don't know. I have no idea what these payments are specifically for because I've never seen a contract between KJM and Sino Eagle.
Let's turn over to 1636. Again, we have a KJM Marine bank statement and the payment records here on the next page. Now, March 2024, we have 3 rows of bank charges. Again, this is spelling number 3 for Aquila. And the 4th payment is a very large payment to Aquila for $588,000. You see that?
I do, yes.
And again, do you have any reason to believe that's anything other than the Aquila vessel, which is subject of these proceedings?
Your Honor, I have no reason to believe that these payments are associated with anything we've been doing with KJM and the Aquila 70.
And let's turn over the page to 1638. Again, this is a KJM Marine bank statement, yes?
Yes.
And now if we scroll down, we see it's a week later, the 20th of March. And again, the top 3 rows of bank charges and the bottom, so the second row on page 1639, you'll see there is the payee is Sino Eagle. Do you see that?
I do.
And again, the reference is Aquila, yes?
Yes.
And the same question again, that do you have any reason to believe this is for anything other than the yacht which is the subject of these proceedings?
I have no reason to believe this has anything to do with the Aquila 70.
So what I suggest to you on this issue, Mr. Ivankovich, is that you promised repeatedly to Parouche and Mr. Jasmine that you would make payment to accept that.
I do not.
That you made promises unconditionally and as well as repeatedly to accept that.
I do not.
That you never once raised a survey as a stumbling block for payment to accept that.
I do not.
That if you hadn't seen the survey, you waived your right to review it. Do you accept that?
Absolutely not.
and that in reliance on your promises, KJM spent its own money, which we've just seen there, to keep the deal alive. Accept that?
I absolutely do not, and I am certain if KJM spent more than the $1.6 million, they would have advertised it and let it known in the email. So that statement is dubious, and I do not accept it, Your Honor.
So let's now talk a little bit more about the Sunseeker yacht. And just before we go into this, again, let's just be aware that His Honour isn't going to be, he's not finding out, he's not going to make factual findings about exactly what happened with the Sunseeker yacht. So we're looking at broad themes here rather than the forensic detail of that transaction. Is that clear and understood by you?
Only in so much as that's what you're telling me.
So for the Sunseeker purchase, in broad terms, do I understand it right that that was purchased or agreed to be purchased in December 2022?
Sitting here, I don't have the exact date, but that time period sounds accurate.
Well, let's just have a quick look at your witness statement, page 649. This is the joint venture claim witness statement. Paragraph 35. If we scroll down a little bit, please, on the page. Here we are, which was, you see, just towards the bottom of the page, it was purchased from One Water on the 23rd of December 2022 for a purchase price of 11.5 million. You see that?
Yes.
So as I understand it, the original purchase price, or the perhaps it's the retail price, of 18.5 million. Is that right?
I recall that there was a version of a starting point of some sort of MOU or letter of intent that was presented to me with that number, but only one time. So
from your perspective, the sale process to you started at 18.5 million. Is that right?
No, not to me. That, as I recall, I believe that event happened, Your Honor, at the Fort Lauderdale International Boat Show. And one of our employees, along with Perush, brought me a document from One Water Yacht Group about a Sunseeker at that price, and I remember kind of chuckling.
So Sunseeker was looking to sell it for 18.5 million, and you did you originally agree a purchase price of 12.5 million?
I wasn't actively involved in the negotiation between One Water, so it's hard for me to comment on that.
Okay, so what we do have is page 1206. Yes, I'm afraid this is a very hard message to read. I've actually had to copy and paste it into a different document. But let's have a look at the first bullet point, which talks about the Sunseeker transaction. It started in September 2022, and Perush, primarily sales professional, earning a brokerage fee. Based on your request for the Perush efforts, the price dropped down from an ask, let me scroll to the right of it, please, of 18.5 million to 11.5 million, even after the deal being agreed for 12.5 million by one of your direct employees. So do you agree that that's an accurate summary of the commercial discussions?
I do not.
You don't agree?
I don't agree.
What is wrong with that summary there?
Your Honor, that is a self-serving, unsolicited post facto email by Mr. Al-Jasmi. I believe I started negotiating. I told him to go back to the Sunseeker and offer them $8 million.
Of course, negotiation involves one person saying high, the other saying low, and you meet in the middle. But they wanted 18.5. You originally agreed at, well, one of your employees agreed at 12.5. Is that right?
One of my employees doesn't have the ability to bind any of our companies in a contract, and I have no knowledge of any employee agreeing to 12.5 for a Sunseeker yacht. And if he did, it would have been irrelevant.
But the final purchase price you accept is 11.5 million.
That is correct.
Now, Parouche brokered that deal, and he earned $180,000 commission. Does that ring a bell to you?
Your Honor, that is a generous way of putting it. I found out that Parouche and Mohammed received what I would call a backdoor payment from One Water Yacht Group, who complained to me about it, that they came back to them again to seek another, what in colloquial terms is called a backhander. But that was never an agreed upon or disclosed commission. And to my understanding from One Water Yacht Group, they increased the purchase price by that amount to be able to pay that to Parouche and Mohammed.
So we can just see the dialogue between One Water and between One Water. I'm not quite sure where this then becomes external, but let's have a look at 1191 just to follow through the story. So Brian Brayley, he's someone at One Water, is that right?
He seems to be the president.
And then, oh yeah, sorry, I was in my hand. My printed version is not as clear as that. Yeah, so he's a president of One Water. He's writing to Parouche, and he's saying in total, Parouche is going to get $180,000 commission. Do you see that?
Yes, I see it's correct.
And then if we scroll up to 1190, at the bottom of that page, below is the commission agreement with the buyer's broker on 100. This is also his first commission payment. And then the top of that page, this is now some months later in October 2023, then a communication about the commission again. Do you see that?
I do.
So from One World's perspective, they were being perfectly open about the fact this is a commission, not calling it a backhander.
One Water, and they certainly weren't open to me about it. Parouche was never the buyer's broker. I never hired the buyer's broker. I never agreed, or was it disclosed, that Parouche and Mohammed would receive a commission about this. So I was never copied on these emails. Nobody, this was completely done opaquely to me and without our agreement.
And this all came to light for you in March 2024 or thereabouts, did it?
That sounds about right.
And that, if we're trying to find a moment in time when your relationship with Mohammed and Parouche deteriorated, it's when this information came available. Is that a fair summary?
No, I think the deterioration happened well after that, but this was certainly disappointing to me. And I recall a conversation in Dubai in my office at the factory with Parouche saying, please don't do this again. Put the money back in the company as my capital account. Let's move forward.
Now, just to confuse matters a little bit further, the Sunseeker 100, do I understand that it was due to be named Contessa?
Correct.
So we have Contessa the company and Contessa the yacht.
There are several Contessa companies and Contessa the yacht, correct.
Okay. So this particular Contessa yacht, it was going to be Jamaican flagged, is that right?
No. It was at the time of purchase, and when it was registered, it was Cayman Island flagged.
So I found a Contessa yacht at page 1680. Let's just have a look at that. This is from one of the US court judgments. And if we look towards the bottom of that page, there's a sentence starting 6 lines up, starting in addition. You see that?
Yes.
So this is a 2023 Sunseeker yacht flagged in Jamaica under the name Contessa. So that looks to me like it must be this vessel. It's a 2023 yacht, Sunseeker, and it's Contessa.
Well, the answer is it is correct, but it is incorrect. The vessel is actually a 2024 vessel. At the time of purchase for 2 years, it was flagged Cayman. When we decided to keep the vessel, we reflagged it Jamaica.
So that is, but what the judge is referring to there is this vessel, the one we're talking about now.
Yes.
Thank you. When were the payments out for the vessel? When did they all happen?
I don't understand the question, Your Honor.
Well, the $11.5 million, when was that actually paid out to Sunseeker?
Are you asking me for specific dates, sir?
I'm as specific as you can provide. It's up to you how if you answer the question to the best of your ability, please.
To the best of my knowledge, we paid a total of $11.5 million to purchase the vessel. I believe it was comprised of a deposit and a final payment.
So the deposit, I'm assuming, must have been no earlier than Q4 2022, because that's when this purchase all is being talked about.
Your Honor, I don't specifically recall the date of this deposit, other than it was after the initial contract was signed.
And the balancing payment must have been in Q1 or 2 of 2023, because you already had delivery of the vessel towards the autumn of 2023. Is that right?
It's possible that the payment was even made prior to that, but certainly by that time.
What was the expected sale price, the onward sale price of the vessel?
Well, it was undertaken to me by Mr. Al-Jasmi and Mr. Hyderabad-Wala that even prior to the completion of this vessel, that they had a buyer for $15 million for this vessel. That buyer never materialized, and I found out later that the vessel at the direction of Mr. Hyderabad-Wala was specified for U.S. electrical fitting and current, which would have been odd if they had a buyer in Dubai, which would have been under the British 220 volt and prong system. So led me to believe that the alleged $15 million buyer that they said they had, which I think we identified previously as Fahad, was a ruse.
But Mr. Rankovich, before you parted, or your family companies parted with $11.5 million, you must have had some sense as to the onward sale price you wanted to achieve for the vessel. What was that?
More than 11.5 million.
As simple as that? You had no fixed view at all?
In my world, making money is good, losing money is bad.
Is it fair to say that you had, having committed that level of cash on the vessel, you had limited liquidity?
Me personally, or my family?
The family companies?
Not at all.
No.
If we had limited liquidity, we would have financed the vessel, not paid cash for it.
That you needed it to be sold in order for your liquidity position to be better? to accept that?
I do not accept that because that was the case. We would have sold it by now, but we still own it. We don't need the liquidity.
So is your evidence that your liquidity position was entirely unaffected by this purchase in 2023?
Correct.
Let's have a look at a couple of other events in 2023. On the 18th of May 2023, the Illinois court made an interim fee award for $425,000. That's at page 898. Do you see that? And there's just at the end of numbered point 1 in the order, there's a requirement for you to pay, and I say you here, it is a personal order, for you to pay this amount of money within 45 days.
Yes.
And you didn't pay that amount of money within that period of time, is that correct?
That's correct.
And apologies, this document, here we are, I was thinking I made an error on the numbers, but we do have $400,000 on paragraph 1 and paragraph 5 is $25,000. You see that?
Yes.
So it's fair for me to say it is $425,000 in total that you had to pay in 45 days.
Correct.
And is it also correct for me to say that you did not make that payment in time?
Correct.
And that your evidence to the court is that you could not pay the money in time?
Me personally, correct.
Yes. And that's what you say at let's just take you to it. Page 654, paragraph 50 of your first witness statement. You say your evidence is, I failed to make this payment to Jeanette by the deadline prescribed by the court, as then I had no direct means of doing so because of our family's sophisticated estate planning. And that evidence is accurate, is it?
That's accurate.
Now, the consequence of not paying is that you were held to be in contempt of court. Is that right?
Correct.
And we see that at page 1097. And we see again a reference there to the $425,000 and the order. And it's a finding of contempt in the operative part of the order there further down the page. And if we turn over to 1098, please. The order continues here. And you see in the middle of the page it says, it is therefore ordered and adjudged that the contempt law, that's reference to you, is committed to Cook County Jail, there to remain until she shall have purged him herself of contempt by paying an all-cash bond of $425,000. You see that?
I do.
And you didn't appeal that order, did you?
My understanding is it was unappealable because it was an interim order.
And we then see over the next page, page 1099, this is a body attachment order, so which means effectively an order for your arrest. And that says at paragraph 1 that any deputised law enforcement agent can seize and apprehend you. Is that right?
Correct.
And just we can see the full body of that order itself that continues over the next 2 pages. I'll just pass that through the screen. So again, we see the requirement of a payment of this amount of money as a bond in cash, and then conditions of the body attachment order are at page 1101. You see that?
I do.
And again, that order was not appealed by you, was it?
No, we did not.
The order remained outstanding for 6 months, is that correct?
Until it expired, correct.
So that means that within that whole period of time, you didn't actually make the payment of $425,000.
That is correct.
And that was all happening. You see on the page there, September the 6th, 2023. This is all happening at precisely the same time when the balance payment for the Aquila fell due. That's right, isn't it?
It seems to be, yes.
So, in fact, Mr. Ivankovich, the plan was to sell the Sunseeker and then use those proceeds to pay off all your debt, wasn't it?
Absolutely not.
And we can see that if we look at page 1095, this is a document we've seen before. These are the minutes of the meeting from 23rd of August, paragraph 1. By 23rd of August, you're expecting payments to be received for the Sunseeker yacht. You've told us that that never completed. By December 2023.
That is an incorrect reading of that statement. The first sentence says, Mohammed informed that payments from Fahad are expected on Monday for Sunseeker yacht. I never expected them. Those were Mohammed's words.
Well, that's someone telling you someone's going to be buying the Sunseeker yacht on Monday, correct?
That's what was said in the meeting by Mohammed, it seems, yes.
And it was recorded by Ollie Hand in his minutes as well, yes?
Yes, correct.
And at that time, you believed him?
At the time, I did, yes.
And there was no reason for anyone to be saying anything other than the truth there, that everyone did expect Fahad to be paying the money on the Monday, yes?
At the time of this statement, I believe so, yes.
But it's common ground that he didn't make the payment, yes?
Correct.
And instead you were trying to look at other ways to sell the vessel in 2023, is that correct?
In 2023, we moved it to the US to bring it to the Florida International Boat Show for sale, correct?
So you tried to sell us at the Florida International Boat Sale. When was that boat sale?
I believe the Florida International Boat Show takes place in the fall of every year.
So to translate that into more precise dates, is that September, October?
It could be. There's a whole string of South Florida boat shows starting with, in succession, Fort Lauderdale, Miami, and Palm Beach, and they all sort of blend into one. So it's kind of the season. I couldn't tell you specific dates.
And when does that season finish?
End of November, just before Christmas.
And then, so we know that the Sunseeker didn't sell despite being marketed through that period. Is that right?
It didn't sell at the price we wanted it to sell, correct.
Then page 1161. This is an exchange we've looked at before, but we see at the bottom of that page a suggestion from Harouche, why not list the 100 on USA websites privately? So that's a suggestion by him, which I think we now understand comes after the Florida boat sales, where he's saying, why don't you try and sell the Sunseeker in a different way? Is that right?
Correct.
And we see in fact, the rest of the exchange over the page at 1162. And your response is that, and he was passing on that there's a few brokers looking to sell it. Your response is getting there. We have 2 to 3 people looking at it. One water has a client as well as a Mexican broker. If nothing catches, we will consider next steps. You see that?
Yes.
So the answer is at that time, you're actively marketing the vessel and you were trying to sell it.
No, we weren't actively marketing it, I would say. It was quietly for sale, just as everything's always for sale.
Now, let's look onwards by the 7th of March 2024. Your email of 1201. Again, we've looked at this email before. Again, these are the different bullet points. your comments after Mr. Al-Jazmi's headlines. And here on the Sun, we have the Sunseeker being mentioned in that final bullet point. As you know, the delay in selling the Sunseeker created an unforeseen negative delta hour of liquidity position. So unscrambling that and having now seen the story, I think we can see here that you had hoped to have sold this vessel between September and November 2023, but that it hadn't sold. Is that right?
We'd hoped to sell it, correct.
And the failure to sell it created an unforeseen negative delta for your liquidity position. Yes?
That's what's written there, you're correct.
And by that, in straightforward English, means you had a liquidity problem because it hadn't been sold.
Momentary at the time, and by liquidity I meant cash.
Yeah. And that's and really what you were saying there, linked to the Aquila 70, is that due to the failure to sell the Sunseeker, you didn't have the cash available to make the balancing payment for the Aquila vessel. That's right, isn't it?
That is not correct.
And that's what Mr. Al-Jazmi understood by your comment. Let's see his reply at page 1200. He deals with this at numbered point 3. Can you see that? As we zoom in further.
I can't read it, thank you.
If you just read that paragraph to yourself.
I do see point 3. Yes, is there a question?
Well, can you please read the paragraph to yourself first, and I'll ask you a question.
I've read the paragraph.
So do you agree that in basic terms, what Mr. Al-Jazmi was saying here is that the failure to sell the Sunseeker is your problem, not KJM's?
Not at all. And as a matter of fact, the substance of that paragraph is just patently untrue.
That what Mr. Al-Jazmi is saying is that he will try to buy more time for you with Sino Eagle, but he can't guarantee anything. That's right.
Your Honor, Mr. Al-Jazmi is not buying more time for me or my family, but for himself in order to fulfill the obligations of the contract. Those are just entirely self-serving comments because he did not fulfill the terms of the contract. If in fact, with us, assuming there was a contract for the Aquila 70 with Sino Eagle.
And his final sentence there, he's giving you fair warning that if he can't buy more time, the factory will keep the deposit for itself. Yes?
I did not have a contract with the Sino Eagle factory. My agreement was with KJM and Mr. Al-Jazmi, which they were obligated to fulfill. What contractual obligations, which I was never a party to or ever saw between KJM and Sino Eagle, were between them.
So this is one of the first times we have the deposit forfeiture being mentioned. And what we don't see in response to this is an email from you saying, hang on, nothing to do with me. What about the survey? What about my contractual rights? There's none of that at all, is there?
I shouldn't have to. It's implied. We sign an agreement.
So, and the reality is you understood perfectly well that if you didn't pay over a balance, you would lose the deposit, yes?
We wouldn't lose anything.
And we see more about the liquidity issues as 2024 carries on. On the 10th of June 2024, that's a date when 4 family companies went into Chapter 11 bankruptcy. Do you remember that?
I do.
And the the plan that was ultimately approved by the court is at page 1647 of the bundle. This is a judgment which then carries on for the next 40 pages or so. We see here at page 1675 the precise page, precise paragraph. Starting notwithstanding the following, foregoing. Do you see that in bold?
Yes.
Maybe if we zoom in ever so slightly, please. And scroll down slightly so we can see the text which follows, notwithstanding the foregoing. And if you read that through to the end of the page, and the sentence carries on to the first line of the next page.
Yes.
So the order made by the Florida court in September was that your ex-wife secured a second charge over the Sunseeker vessel. This is the Sunseeker 100. Yes.
Where do you see that?
Sub paragraph B.
Okay.
If we
Where
just
do you
scroll
see
up a
that?
little bit, here we
Well,
are.
Sadly, Your Honor, she is still my wife, not my ex-wife, although that is the plan. And where do you see that my soon-to-be ex-wife has a mortgage over the Sunseeker?
So let me just walk you through it a bit more. It says, notwithstanding the foregoing, no provision of this confirmation order, other than those provisions regarding payments of creditors and the assets used for payments, may be used to limit or restrict the rights of Jeanette Ivankovich or Sheila Ducanto and Fleck. I'm assuming, pausing there, I'm assuming that's her lawyers.
Correct.
Is that right?
Yes.
So there is a great big exemption in the effect of this order, that whatever's going on for Chapter 11 bankruptcy, it won't prejudice her rights as against you, correct?
Correct.
And also as against the Ivankovich companies, correct?
Correct.
Then we have, the text carries on, the debtors claim or may claim an interest, and then we have A, the planned guarantors shall be second in priority to the first priority lien granted to Dr. Olga Ivankovich and Dr. Anthony Ivankovich, that was your parents, yes?
Correct.
And then B, the Sunseeker shall be second in priority to the first priority ship mortgage in favour of P5GRA LLC. So what we learned from this is that there is money lent. There's a loan secured against the Sunseeker. Is that right?
It's not a loan. It's a priority guarantee as stated.
Okay. And how much is owing under that priority guarantee?
I don't know. I'm not party to those documents.
And the second in priority guarantee or the second in priority element there, is that anything to do with Jeanette Ivankovich?
I don't believe so, no.
So what I suggest to you we learn from this is that there's a restriction on you selling the Sunseeker, and or even if the Sunseeker were to be sold, not all of the cash would make its way through to you because other debtors would have to be paid first, other creditors would have to be paid first. Is that right?
There would be no cash from the Sunseeker that would come to me from the sale of the Sunseeker.
I think you're on mute, Your Honour.
I said this is extraordinarily hard to follow, and I won't make any comment on the drafting.
I'm
but
sorry. Did you say I was on mute?
No, me.
Oh.
Okay. But as I understand it, there is a plan. Then there's an exception to the plan in favour of Jeanette Ivankovich. Then there's an exception to the exception in relation to the ship mortgage. Is that right?
Your Honor, if I can take a layman's stab at what I understand the outcome was, if I'm not sure if that would be helpful. My understanding is that so the purpose of this language is that my soon-to-be ex-wife could continue to litigate in the Chicago divorce proceeding, that a bankruptcy would potentially wipe out all claims. She did try to make an attempt against my parents and these companies. That is, against my parents directly, that has been wiped out. They have the right to reorganize all of these debtors and have a first priority lien against them. And then there is a third company, in addition to these fourth companies that were sub-companies of the debtor, that also have a lien against the Sunseeker. So essentially, my parents have a first priority lien against all of their assets, including the Sunseeker, in this adjudication. That's my layman's understanding of the outcome.
What we do see, Mr. Rankovich, if we look at page 1665, the reader at this point is rewarded with a footnote written in standard English, finally. Footnote 5, you'll see there it's the judge's finding that this is all linked back to your divorce proceedings. Do you see that?
Correct.
And do you accept that that's the judge's finding of fact?
That's what she wrote.
So, Mr. Rankovich, I suggest that from mid-2023, you were short of cash because you had, or found your family companies had paid out a lot of money on the Sunseeker vessel. Do you accept that?
I don't accept that we were short of cash.
That the balancing payment for the Aquila vessel awaited the sale of the Sunseeker yacht. Do you accept that?
I do not accept that, and that is factually incorrect, Your Honor.
The Sunseeker never sold. I think we agreed on that point, yes?
The Sunseeker never sold. That is correct, Your Honor.
And that's the reason why the balance for the Aquila was never paid. Do you accept that?
I do not accept that, and that is factually incorrect.
And clause 2B of the contract had nothing to do with this in reality, did it, Mr. Ivankovich?
Clause 2B of the contract, which has everything to do with KJM not fulfilling the contract and not completing the transaction.
And it's only after the event that you and your lawyers have alighted upon clause 2B, and the unsatisfactory report story that has been created for the purpose of this claim. That's right, isn't it?
That is categorically incorrect.
Let's have a look at the conduct of July and August 2024. We've already looked at some of this, so I hope we can move through fairly quickly. We'll pick up the story on the 11th of July, page 1286. So it's common ground that on the 11th of July, Mr. Radwan sends over the report and a corrective actions document, and Mr. Moore responds to say it's not satisfactory or not sufficient. We get that, I think, at 1302. So that's the 22nd of July, and that's Casey Flitman's email. Then the 30th of July 2024, so another week on 1296, that's when we have the wire instructions being asked for. We've looked at this, you recall that?
I do.
And I suggested that email was sent on your instructions, Mr. Rankovich, is that right?
The email from Michael Moore?
Yes.
I don't recall instructing Michael Moore to send this email, but he did send it.
He wouldn't have asked someone to provide the wire instructions for payment without first checking with you whether he wanted to make payment. So surely you must have asked him to do that.
I don't recall, and unlike the Brits, which I know require specific instructions, American attorneys can act independently.
Then let's have a look at 1321. I'll start this at 1322. So after we saw the earlier email asking for the payment instructions, Mr. Radwan replies with the pro forma invoice and wire details. And that document we've already had a look at, and that's at 1320. Jumping around here slightly, but you'll forgive me for moving quickly, given we've looked at some of this material before. So this is the pro forma invoice that Mr. Watson helpfully flagged up as being the document we think is attached. And it says there in the middle of it, balance of Aquila 70 yacht. You see that?
Yes.
Yes. And then we have Mr. Moore's email back at 1321. So in reply to this invoice, he says, I beg your indulgence, it's very late moment in the process. I had a very productive conversation with Stephen Rankovich today. The good news is that he does wish to close on the purchase of Aquila. You see that?
Correct.
And so there's a statement here that you would make payment of 2.39 million. Yes?
Under the terms proposed here, correct.
Yes, exactly. There's no trick in what I'm going to say to Mr. Rankovich. We can turn over the page and we'll see some requests from Mr. Moore. And there's a request for you to send a representative to the yard to do a pre-delivery inspection. So that's going to be Mr. Hand, is it?
Ole and Yon, yes.
Well, your representative is going to be Mr. Hand, I suggest to you, so not a surveyor. Do you accept that?
No, it was Ole and Yon were both going to go.
So I suggest to you that you were content to proceed with it, subject only to having a fresh look at the vessel. And the 24 items on the snagging list were not an obstacle to take delivery. Do you accept that?
I do not accept that. That is factually incorrect.
And there's no mention of those snagging items here at all in one of these conditions, is there?
There was a mention of an overall inspection.
And there's also no specific objection to the report's age as well. You accept that?
There are numerous references to the objection of the report's age.
In reality, Mr. Rankovich, this email was sent in your instructions to play for a bit more time, wasn't it?
Not at all. I was willing. It was very alarming to me that we were offering Your Honor, a pragmatic solution to complete the purchase, which actually financially would have been better for KJM. And I took the vessel in my name. Mr. Radwan agreed to it. I suspect he didn't check with his client if it was agreeable because they backed off it and never allow us to complete that transaction or ever interact with the factory directly, because I suspect they were probably getting another backhander and they didn't want us to know about it.
Mr. Rankovich, I suggest to you that in reality you were trying to string things out a little longer because you didn't have the cash available to pay the balance. That's right, isn't it?
No, but I was trying to get to the bottom to see what the transaction was really like, if it was a real transaction, and if there was money flowing to our partners without being disclosed to us. That's why I wanted to buy the boat directly and in my name, because I smelled a rat, as they say.
Okay, let's just have a look at some payment issues from your side, if we may. Do you accept that Contessa itself paid nothing for the vessel?
I don't know what you mean by that comment.
Well, who was the payer of the $1.6 million?
I don't know where the monies were wired from, but Contessa was responsible for the payment.
Well, let's have a look at who wired the payment. It's page 894 of the bundle. See the top there, Glencoe Family Dwelling LLC.
I do see
Yes.
that. Yes, correct.
And then this bank statement goes on for a number of pages, but at 896, we see the wire transfer. You see that?
I do.
So the paying party was actually Glencoe, wasn't it?
They did make the wire. They did remit the wire for the deposit. Yes.
Now, in your evidence, you tell the court that there's an arrangement between Contessa and Glencoe. Yes.
Correct.
When was that arrangement made?
I don't recall. Both companies are 100%. Well, they were owned by my father, who passed away several weeks ago. But Glencoe Family LLC was 100% owned by Anthony Ivankovich, as was Contessa Marine Research. How he conducted his internal business and tax planning was be him and his advisors, but I was advised that that's how the transaction was to be documented and proceeded.
Well, I suggest to you, Mr. Ivankovich, that there is no evidence of any arrangement between Glencoe and Contessa. Do you accept
Your
that?
Honour, before the witness answers that question, I feel I must object. Given that my learned friend's pleaded case is that Contessa paid the 1.6 million, and there was never any request for disclosure about this issue, to put to Mr. Ivankovich that he hasn't produced any evidence is not proper.
Well, I have to say that given that there's a group of companies operated by the Ivankovich family, and with some knowledge and experience of how family offices and family businesses work, I'm not massively impressed by this point. But if you wish to pursue it, Mr. Page, that is entirely a matter for you.
Your Honor, I'm more than happy to take your hint. I shall gladly move on. I think what I will just look at, Mr. Ivankovich, just a few other payments, if I may. So we've dealt with that payment by Glencoe. As you mentioned, I think in your evidence to the court, Glencoe is a company beneficially owned by your father. Is that right?
It was.
Excuse me, your late father. I'm so sorry.
Yes, thank you.
And you are a director of that company. Is that right?
In the proper corporate parlance of a LLC, I would have been. I was the manager, which is directly the equivalent, which is the equivalent of a director under British corporate parlance. Yes. Just for clarity's sake.
Of course. The A&O company, that is or was managed by your parents. Is that correct?
Your Honor, for the sake of clarity, we do have a fairly complicated family office structure. They are two A&O family LLCs. One that's a Illinois domiciled A&O family LLC. The other that is a Florida-based A&O family LLC. I just to know that there's a distinction, and so you can just specifically ask me which one you're referring to, so I can answer precisely.
Well, I think we learned this at paragraph. Here we are. It's the A&O Family LLC. It's that company. That's one managed.
Which domicile of that particular company, Illinois or Florida?
Florida.
Okay, thank you.
So that company is or was managed by your parents. Is that correct?
Correct.
And you have no beneficial interest in that company. Is that right?
Correct.
Now, in terms of the 1.6 million, you personally arranged for that payment. Is that right?
I would have had to sign off on it with the bank, but the arrangement would have had to, in the broad sense of the term, been approved by ultimately by my father.
And also, you would be the person directing the payment of any balance. Is that right?
I think I know what you mean by that question, sir. Can you please clarify that?
Yes, I just want to understand that I'm understanding correctly. Paragraph 36 of your first witness statement, page 82. So we have there in the middle, I instructed Michael to write to Mohammed Radwan informing him that I would make the transfer of the remaining purchase price directly to sign illegal. You see that?
Yes.
So when you use the word I there, what do you mean? You mean you personally or a company?
No, that I would direct to have it made in the appropriate way of our family office structure.
And that the owner was to be you personally or one of your assigns. Well, we've seen that email, haven't we?
It wouldn't have been, I believe what was contemplated, Your Honor, by Mr. Moore was that I would initially be the direct owner of the contract until a appropriate company was set up to take possession of the Aquila vessel.
And
that is the precise order of events. I would never have taken ultimate ownership of the vessel in my name.
Let's just look at a few other payments. These are linked to the KJI case. 1164. We need to get the assessed. All we have in terms of the account name there is a handwritten note at the top. I think this is from you, Mr. Rankovich. AO. So this is an A&O company making a payment here. Is that right?
It would appear so. I don't know, but that is the notation.
And is that your handwriting at the top?
It is not.
Okay. But if we just turn through to the next page, we see AO being written again. So 1165, we see on that page another payment being made there to KJM, and 1166, a third payment being made to KJM. See that?
Yes.
So it looks like the paying companies were Glencoe and one of the A&O entities. Is that right?
Can you please clarify that the paying companies for what specifically?
Well, we have here different things going on. So we've looked at the Glencoe payment, and that's for the Aquila vessel. And these other payments, as I hope I fairly stated at the start, these are linked to the joint venture agreement. So the A&O payments are linked to the joint venture agreement.
Well, in the broad sense of the term, Your Honor, there were numerous third-party vessels during the time purchased that Mr. Al-Jasmi was arranging. So in a broad sense, it could be construed they were part of the JV, but there was lots of money flowing to KJI and KJM from the Ivankovich family at that time for different purposes, but all maritime related, I would categorize.
And we see an example of that, Mr. Rankovich, at page 1140, because here is a payment from Glencoe, it looks like. And if we see there, there's a payment reference of Arrow.
Yes.
Do you see? So that looks like it is linked to a vessel rather than the JV broadly. Is that right? Is that fair?
No, that is incorrect, Your Honor. The Arrow was actually the first vessel contemplated to be designed, built, and sold by the joint venture. And that was the initial deposit for the production of the first 5, what I would call prototype Arrow vessels.
But Mr. Rankovich, we can now move on to the joint venture claim in a bit more detail, and we'll perhaps do about 10 minutes of this and then take our mid-afternoon break, or you might finally get to a mid-morning break for you.
Early morning break for me.
Early morning break. Can I check, Your Honour, are you content if I carry on for 10 minutes or so?
Yes, I have no problem with that.
So in terms of the basic chronology, let's just orientate ourselves. Do you recall the joint venture agreement was signed on 20th of March 2023?
I do recall that, yes.
And it was largely drafted by your lawyers at KGM's offices. Is that right?
I recall that both Mr. Rodwan and Michael Moore and Casey Flitman were involved in the drafting together.
So lawyers on both sides drafted it.
Yes.
Is that right?
Yes.
And that required payment, effectively a bullet payment of $2 million within 30 days. Do you recall making that commitment?
I don't believe it was a bullet payment, but my commitment to the joint venture was a total of $2 million. Yes.
Well, let's just have a look at the contractual language here. So page 881 is where the joint venture agreement starts. And then at the bottom of that page, paragraph number 1, you have the reference there to initial contributions. And over on to page 2, subparagraph C, you'll make your initial contribution within 30 days of execution of this document, and that's going to be $2 million. You see that?
Yes.
So on reflection, is it fair when I describe it as a bullet payment of $2 million within 30 days of signing?
In this version of the agreement, that's what it says, correct.
But you agree that you didn't make payment in time?
No, I don't agree. Your Honor, the contract, this JV agreement was modified to reflect the business realities of the joint venture once we had a specific budget for specific line items to be paid, and when we deemed that KJM's facility was inadequate for our needs and moved over to a new facility, which it seems that my family entirely paid for.
So, Mr. Rankovich, you have been saying a few times, so you're a real stickler for detail. So let's just look at it properly together. Page 889. We have the date and the signature of the document on the 20th of March, 2023. You see that?
I do.
And so within 30 days of that takes us up to the 19th or 20th of April, depending on when you count from. Yes?
Correct.
And you didn't make payment within that time, correct?
I didn't make payment that time. That's correct, because there wasn't a suitable budget and uses for that payment provided to us until later.
And that was in breach of contract, wasn't it?
No, because the contract was modified to reflect the realities of the business going forward.
when was the contract modified?
I couldn't tell you the exact dates, but there's a supplementary document that details the uses for the $2 million source. It was, within 6 months of the signing of this document.
Yes, it was actually, it was closer than that. 21st of April, so that's page 893. You see your signature there. So it's after, but just after the deadline lapsed. We then had an agreement to extend payment by 15 days. No particular proposal there that any structure should happen or anything else should be made different. Effectively, you were just given more time to pay. That's right.
Well, Your Honor, it was beyond that. The company, actually, KJI, wasn't set up. There wasn't a corporate entity to pay that deposit to. So the extension was actually given on behalf of the other shareholders who had failed to actually set up KJI Boats Manufacturing or a corresponding bank account.
But you accept, Mr. Rankovich, that this contract could have said words to the effect of payment will be made into a KJI bank account after it's been created. But it doesn't say any of that. It's simply, it's going to be payment now within 45 days of the original deadline. See?
Your Honor, I accept that this contract could have said many things.
Okay, but it doesn't actually say what you wanted it to say. You accept that?
It didn't need to.
And you didn't make payment within 15 days, did you?
Your Honor, we had nowhere to make a payment to.
So you accept that you're in breach of contract by not making payment by 10th of May 2023?
I don't, because this contract contemplates that KJI Marine Boats Manufacturing LLC would actually exist in order to make this payment. It did not.
And that then gives rise to a further amendment to the JV agreement, and that's at page 913. Let's have a look at that together. So we can see there at the top, we have mention of the original JVA, 20th of March, the first amendment, 21st of April, and then paragraph 1 is deleting all the previous payment obligations. And now we have slightly more than $2 million payments being stretched out over a multi-tranche process. You see that?
Yes, I do.
So that envisage now quite a different thing. Now we are talking about payments linked to events on the ground. Yes, you said that?
I do.
Yeah, where did these numbers come from?
Your Honor, are you addressing that question to me?
Yes, yes. We've got very specific numbers down to small numbers of cents.
Yeah.
Where did this calculation come from?
The budget was provided to me by Mr. Al-Jasmi. As I mentioned previously, the KJM facility, which they were supposed to contribute to the venture, was ultimately deemed inadequate. So this budget was created specifically around a new facility that was leased and renovated with the funds I provided. So this budget was originated by Mr. Al-Jasmi or his team in some form.
And did you see anything more than these numbers?
No, I assumed based on the agreement that, we would be provided backup in the normal course of business during accounting meetings, but never any underlying detail other than these numbers.
Thank you.
I wonder if that's a convenient moment.
Yes, sure. Let's take 10 minutes break now and come back at 25 past the hour. Thank you. Are we ready to proceed?
Mr. Rankovich, you're on mute, I'm afraid.
Some people would welcome that. Thank you. I'm ready.
So, Mr. Rankovich, let's move on then, please, to the some other aspects of the joint venture agreement. So, in the original agreement, it was envisaged that there would be 3 initial directors. We can see that at page 884. Do you see that?
Under number F, Board of Directors, yes.
Yes. And those directors will all be appointed at the outset, with with subparagraph C, Mr. Jasmy being the executive director. You see that?
Correct.
And at that time, KJI didn't exist. That's common ground, isn't it?
Your Honor, I don't believe it existed on the ground or in the air, but yes, it didn't exist.
And it was already in the water. It was brought into existence on the 19th of July 2023. And we see that through the Memorandum of Association at 1038. And you've seen this document before, haven't you?
I have.
And it's your signature at the back of this document. Let's just turn through to page 1056. And you're the second party there. That's you, isn't it?
That is correct.
And you don't challenge the lawfulness of this document. You accept that it was validly executed.
I accept that I signed it, Your Honor. The circumstances of me signing it, I'm a little disappointed about, but it is my signature on what I believe to be a legally valid document.
And so we see here in this document that the structure of what was ultimately created was a bit different to the joint venture agreement. So page 1038, we can see we now have 3 parties, KJM, you, and Mr. Al-Jasmy. You see that?
Yes.
And that's a change from the original JVA. We don't need to do the comparison, but tell me if you don't accept any of this, where originally it was KJM and you only. Is that right?
Correct, Your Honor, but it was my understanding, because it was told to me that Mr. Al-Jasmy and Mr. Karafi were 50-50 equal shareholders in KJM. So the material difference in my mind would have been the same.
Yes. And we can see here in the middle of box 1, it's Mr. Karafi who is being represented. So who is the representative of KJM Marine? See that?
Yes.
So in effect, there's been a subdivision of KJM between Mr. Al-Karafi and Mr. Jasmy, but your interests are unaffected.
That is correct.
Did you read this document before you signed it?
I remember glancing at it because it was given to me at, Your Honor, I don't know what the formal term for the agency is, but I would categorize it at the corporate register. And by Mr. Radwan, and I just remember that this was a necessary document to be signed to incorporate the company. So I quickly skimmed it. We were standing up outside the offices.
So, and rather than the 3 initial directors, we have 1 director being appointed here, and that we see that's a 1043. See that? That's Mr. Jasmy as the director at this stage. Yes.
Yes.
So Dealing then with the three tranches of payment set out in JDA Amendment 2, let's have a look at that again. 913. Tranche 1 was 611,000 to be paid by 19th of June 2023. You missed that deadline, didn't you?
The answer is I don't think so. I think I initiated the wire prior to that deadline. I can't comment on when it was received.
Well, we can see it was received. Well, in fact, we can see it was paid some days late. 1164. So these are your, or rather A&O's bank statements, and that shows the date of payment 22nd of June. You see that?
Yep, that is correct.
So in fact, the payment was late at your end. No one else was to blame. That's right, isn't it?
Well, Your Honor, there's always someone to blame, but in this case, I'll accept responsibility that this was made on 6/22.
The industrial license itself was issued.
So it's just
So,
3 days late.
3 days late, and payment here was being made to KJM, correct?
That is correct.
So previously you've been saying that you weren't making payment because KJI's bank account hadn't been established, but that's
Yes.
no longer a problem by June because you're making payment to KJM.
Well, yes, we just decided to get on with it. I was assured it wouldn't be an issue.
And this payment is being made still before KGI has even been created, yes?
Correct.
The industrial license for KGI.
How can you have a bank account before the company is created? I mean, any bank wants to see the constitutional documents to understand what is the identity of his client.
Yes, that's correct. My understanding, it wasn't created and we didn't have the bank account, which is why we wired to KJM.
So it was wired to KJM, not to KJI. I'm sorry if I misunderstood.
The industrial, and KJI, so we can see this was wired 22nd of June 2023. Then KJI was created on the 19th of July 2023, so about a month later, and it then received its industrial license on the 31st of July 2023. We'll have a look at that at 1062.
So do we have evidence of KJM transmitting the money to KJI?
You're in fact, as I understand it, KJI never opened a bank account.
Okay.
Your Honor, I don't believe that's correct because I do recall making a wire transfer to KJI, but I could be wrong in that. But it was much later in the process.
Okay, well, we'll investigate.
So, Mr. Mankiewicz, we can see here the industrial license, and that is the expiry date on the left-hand side, 30th of July 2026, and there is an issue date, which I haven't highlighted, I'm afraid, but that is 31st of July. I think maybe it's a page before. Anyway, you accept the industrial license was issued, and there we are. It's on the right-hand side of that page, 31st July 2023. It was issued on that date.
I do accept that, yes.
So tranche 2 payment.
Do we know how much that cost?
The industrial license?
Yes.
It's not stated on this document, Your Honour. We can have a look back at 913, where we're going to have a look anyway.
Yes, I'm not interested in what the budget was. I'm interested in actual evidence of cost. So we don't know what it actually cost.
I'm afraid I can't help you with that at the moment. Do you want to know?
Okay, well, that's something we need to investigate.
Yes. So if we go back to the amendment number 2, Mr. Mankiewicz. So we have there the requirement for the first tranche we paid 19th of June, and the budget here for various different elements. Then the second tranche over the page of 914, that was going to be just over $1.1 million to be paid within 5 business days upon all approvals for the build-up. So my understanding of the phrase 5 business days for all approvals for the build-up, it links it to the industrial license. Is that right, or is that referring to something different?
No, that refers to specific buildup approvals of construction budgets for the new facilities, approval of designs. It was a comprehensive approvals of the next phase of the facility. So I would believe the industrial license, in so much as that it was required to do that construction, would have been part of it, but not a significant part.
So when was that threshold reached?
It would have been a notice provided to me by Mr. El-Jasmi, and I would have relied on him to just essentially tell me we're ready for the second tranche. So whenever he notified me, and I do recall asking for backup, but he told me that would be addressed, at the end in our meetings.
And
Well,
did
we
you
don't-
see the actual work being carried out?
Yes, I did come, Your Honor, to the facility with people doing work. As someone who does construction both in America and the UK, it was astounding to me that there were people using jackhammers in sandals and flip-flops, but they were definitely working. I did see it carried out. And of course, I did see the finished product.
So what we can see of capital calls is at page 1137. So first, capital calls. And this is an email from Mr. Radwan to you. It's on date blank. KJI received an amount of $1 million towards second capital call with a shortfall of $151,000. So that suggests that there had been an earlier call for payment and some shortfall in that payment. You said that's what he's saying there?
Well, that's what he's writing. The reality of the situation on the ground, Your Honor, is Mohammed called me up and said, wire $1 million for the next payment, because that was the work that he created, and that's what was wired.
So the wire instructions at page 1165. So this is on the 27th of October. As you say, it's for around some of $1 million. And then, as Mr. Radwan points out, then a month later, that was a shortfall on the second capital call. And then the third capital call is then formally requested back at page 1137. And you'll see there, the third capital call is due, underlined, and there's a request also to transfer the shortfall for the second capital call as well. Do you see that?
I do.
And then towards the bottom of that page, Mr. Radwan says, in order to preserve the capital invested and mitigate the risk of losing it by starting KJI without the core asset, i.e. the mould, KJM has decided to use its mould to serve the manufacturing process of KJI. So we have zero tolerance, neither wasting your financial contribution nor ours. And that's a reference to 20 votes there. That's the arrow, is it?
Yes.
Yes. So we have here a statement by KJM's lawyer on behalf of the joint venture that it's trying to do whatever it can to mitigate the risk of money being lost, and it's getting on with a manufacturing process. Yes?
Yes, that's what's written.
And you accept that's accurate? That they were manufacturing?
No, we weren't manufacturing at that point. And his categorization of the mold is also incorrect.
So if we look back at page 914, see the third tranche to be within 45 days of the mold arrivals. You see that towards the bottom of the page?
Yes.
But we've already seen from this email that the molds have arrived and are being used. Payment is then only made on the end of December, isn't it?
Yeah, that's not a correct portrayal of Mr. Radwan's email or the events on the ground.
Well, is it accurate to say that in that email he's calling for the third payment tranche?
That is accurate, and the third payment tranche was made.
And then you made that more than a month later, on the 29th of December.
If that's what's in evidence, then I have no reason to believe that's an incorrect statement.
And we have that at page 1166. And these are your bank statements, I understand, Mr. Rankovich.
Not mine, but whatever family office company associated with the wire transfer. Yes.
Yes, well, if we just scroll up a little bit, again, we'll see it's AO. You see that?
I do.
Yeah. So, in fact, this is the last payment you make. So, at no time have there been any payments at all from you personally. You accept that?
I do.
And each of these payments we can see are made late. You accept that?
I do not.
And the reason why all these payments are coming in late is because in reality, there are other issues going on with the Sunseeker and your divorce proceedings. Yes?
That is certainly incorrect. I think the biggest issue was I kept wondering why I was making these payments on behalf of the family companies to KJM and not KJI. And also I had requested at least cursory backup for these payments, but never got a satisfactory answer as to why a KJI bank account had not been set up or why I couldn't get accounting backup. But I carried on and authorized these wires anyway.
Well, Mr. Rankovich, I suggest that you promised to make payments of $2 million that you didn't actually have to hand.
I'm sorry, can you repeat that comment, please?
You promised to make payment of $2 million, which you didn't actually have available.
How do you figure, since those payments were made in full?
Well, because we've been through your late payments throughout the period.
I fail to understand how making payments late because there wasn't a proper bank account in place equates to the money not being available to be paid since it was paid, but I'm just not following your line of questioning.
Well, all
The
of these,
payments were made, and reluctantly, because there wasn't a KGI a bank account or sufficient backup to justify the previous payments, but in the spirit of being a good partner and getting on with the business, we made those payments.
Mr. Ankovich, I suggest that the effect of you making late payment is that KGI was starved of money whilst you were scrapping around trying to find liquidity.
Your suggestion is both inaccurate and comical.
Let's look at the companies themselves. Your pleaded case is that the Chapter 11 proceedings didn't involve you personally because you have no legal or beneficial tie to the Chapter 11 companies. Have I summarised that fairly?
That's correct.
So one of those companies was the Ivankovich Family LLC. And we see it 1843. You are described as its manager. If we can look at Article 7, please. It's not there on that page. It's here we are. It's back on 1842. Excuse me. You see the definition of the term manager at the top of 1842.
I do.
Yeah, and that's you, isn't it?
Yes.
Yes. And you were the person who executed this certificate of formation. Is that right?
That is correct. Yes.
And we see that at page 1841. For the Chapter 11 debtors, you filed the confirmation affidavit. That's right, isn't it?
For this company?
Well, for all 4 debtors. Let's have a look. Perhaps you don't recall. If we look at 1648, please. We see there, I'm afraid it's quite hard to follow this text, but hopefully spot your name. It's, from what we can see, 3 lines up from the bottom. A confirmation affidavit. You see that?
Yes.
Yes. And did that cover all of the companies?
I don't know. I'm not really a bankruptcy expert.
We've seen already when we look through at the payments made on your behalf into the JVA that the payer was the one of the A&O offices. Yes, one of the A&O companies.
That is correct.
And there are 2 A&O companies in total, the A&O family in Florida and A&O family in Illinois. Is that right?
That's correct.
Both of those companies went into Chapter 11 bankruptcy. Is that right?
That is correct.
And we see that at page 1647. You also say in your evidence that it's your family office that funded your divorce proceedings. Do you remember saying that?
I don't specifically, but that would be an accurate statement.
So that's page 654 of the bundle, paragraph 50.
Okay.
You see that final sentence? Your family office had been funding my divorce proceedings. See?
Yes.
Yes. And that same paragraph says that you had no direct means of making court order payments yourself. Yes.
Correct.
Now, this may be stretching my interpretation, understanding of Chapter 11 proceedings, but we've already seen in that footnote I showed you earlier from the Chapter 11 proceedings that there's a link between all of this and your divorce proceedings. You accept that?
I do.
The reality is that in practical terms, the assets you call on to meet substantial personal liabilities are your family assets, correct?
Correct.
And those companies hold and deploy your wealth, correct?
I would argue, Your Honor, that I don't have any personal wealth, but it's all part of our family office that I manage or assist in managing.
I suggest to you that any attempts in practical terms to separate yourself from those companies is artificial. Do you accept that?
I don't accept that, no.
And that their Chapter 11 bankruptcy amounted to a material change in your assets and business. Do you accept that?
I do not accept that, Your Honor, and that's not accurate.
Alternatively, that their Chapter 11 bankruptcy rated to a substantial proportion of your assets. Do you accept that?
I do not, and that is an inaccurate statement.
We've already looked at the personal orders made against you. I suggest to you that those personal orders show that you were failing to satisfy judgment debts in time. Do you accept that?
I do.
And that those orders and
Your Honour, I'm sorry for interrupting my learned friend's cross-examination, but certainly for me, the real-time transcript has stopped. I don't know whether it has for Your Honour or indeed for Mr. Page. I just wanted to check. I wanted to know whether it was my problem or whether there was an issue with the transcriber, because I'm sure Mr. Page will want this evidence to be transcribed.
I got to page 162, line 11.
And that is where I've got to, which was my learned friend's suggestion.
This is the court reporter. I'm still here. I'm aware that tech is doing something with the real time, but I'm still here and it's still being recorded and transcribed. It will be here in the final transcript.
Okay, thank you.
Very good.
Thank you.
We've only got a few minutes left anyway. Let's persevere.
Thank you. So the divorce orders, Mr. Ivankovich, I suggest to you that they amounted to a material change in your business and assets. Do you accept that?
I do not, nor do I find that accurate.
In terms of a factory lease and license, let's have a look at an email from Mr. Radwan of page 1349. I'll just turn up my version. You see there that Mr. Radwan is saying in the first paragraph that an external auditor has issued a draft of the annual financials. You see that in the first paragraph.
That's the bullet point, starting with the accumulated losses arising from the JV partner.
No, it's actually before any of that. It's after Salam Alaikum.
Beginning with following up on the trail below.
Yes.
Yes.
And then, so we have some discussion of that point there. Then the next paragraph talks about whether or not KJI might no longer be a going concern company. And then we have 2 bullet points which follow. Do you see that?
I do.
And the second bullet point concerns the factory annual lease. You see that at subparagraph A?
I do.
And the renewal fees of the industrial license, that's little b. And just, do you see that?
I do.
Pausing there, this may help His Honour answer the question he posed earlier about the level of these fees. So, do you accept there was a need to pay an annual lease for the KJI factory?
Yes, there was a lease payment, correct?
And also a license payment.
That is correct too.
And plainly, somebody needs to pay that by the 16th. Oh, sorry. Plainly, somebody needs to pay that by the 16th of August 2024 in order to maintain the industrial license and the lease. Do you accept that?
I do.
You didn't pay that, did you?
Not because I didn't offer.
Sorry, was that a double negative? Are you saying you did offer?
I apologize. Yes, Your Honor. I'm sorry for my poor English. We did offer, and all we were asking for is a proper financial statement to understand where the money had previously been invested to. But we did offer to make, through my attorneys, my 50% portion of that payment, as well as the lease payment.
Well, what we can see in the letter from Trowers, 1355, you have the subparagraphs A and B there. So there is a statement that you stand ready to make the payment. Then there's a rejection that you'll do so by the 16th of August. Do you see that?
Yes.
So in fact, there was no clear promise to make payment of this amount of money by the 16th of August, and you didn't in fact do so, did you?
I did not make it, and the payment was based on certain contractual obligations of the company which had been overdue, which we believe were reasonable.
The essence of the joint venture agreement was for the manufacture of vessels, in large part. Do you agree with that?
Yes.
And that required a factory lease and an industrial license. Do you accept that?
I do.
And do you accept, therefore, that KJI could not lawfully and practically operate without either a factory or an industrial license?
Well, Your Honor, that would be a question for debate, but it definitely needed a facility to manufacture if we were to manufacture our own boats.
Do you accept it as commercially unreasonable for you to refuse to hand over this money, but still insist that the joint venture remain alive?
Your Honor, I believe it's commercially unreasonable to ask someone to keep sending money into a bottomless pit without any transparency or knowledge how that money was being spent.
And so far as you're aware, the factory now has closed. Is that right?
No, I asked somebody to check last week, and they drove by the factory, and according to that report, the factory was still operating.
So somebody drove past last week, it's still operating. It's not being funded by you, though, is it?
Your Honor, it is not being funded by me, nor is it obligated to be funded by me.
So the last time you put in any money was that payment we've seen back in December 2023, I believe. Is that right?
Which payment are you referring to specifically?
It was one of the A&O payments.
Which one, sir?
Page 1166. That one there. That's the last time you paid any money into the JV, isn't it?
Oh, no, that is incorrect. I paid, in addition to the slightly over $2 million investment we made substantial additional payments in excess of our commitment for the manufacture of, namely, the aeroboat research and development, payments for experts to come and assist. We directed a company called Aquaform to come and have parts and boats produced there, which we also pay for. My estimate is we probably funded into KJI close to $1 million of additional payments on top of the $2 million initial capital contribution.
None of that has been broken down for the judge, has it?
Do we have the financial statements?
So I'm just about to now show Mr. Rankovich, if I may, Your Honour, what we do have.
Well,
So,
this is going to take some time, isn't it?
I would hope not, because I'm conscious that I need to finish in very short order. So I'm planning only on really putting the essence of my case, and then a lot of it's going to be for submissions.
Well, it's up to you what you put and don't put, obviously. But we can't go on. It's now 5 p.m. Dubai time, and I can't keep the court staff indefinitely. So how long do you think it'll be?
So
and then there's re-examination, of course.
I have another 3 pages of my notes of 25. So that gives a sense of I really am nearly there.
So let me do the arithmetic. You've got 3 pages of 25. You've taken 5 hours so far.
It ought
You're
to
going to
be
be
no
half
more,
an hour, aren't you?
Well, I would like to be no more than 10 to 15 minutes.
You might like to be, but you're going to go through financial statements now. Everybody knows you can't go through financial statements slowly.
I was only going to put 1 or 2 figures to Mr. Rankovich, in fact, Your Honour.
Okay, look, you've got an extra quarter of an hour, and then we'll see about Mr. Watson and re-examination.
So we were just going to look at the financial statement. He starts at page 1702. Now, the appointment of the auditor itself, that's been contentious, hasn't it, between the parties? But let's have a look at 1717, please, Mr. Rankovich. And we scroll towards the bottom of that page. Here we are. We'll have to see there the shareholders' contributions to the 31st of December 2024. That figure, is that accurate?
Which line item are you referring to specifically?
Excuse me, I'm referring to your contribution of 7.1 million dirhams.
No, I believe that is understated.
And we can see here that KJM's contribution is stated at 1.4 million dirhams. Yes.
That's what is written in the report. Yes.
Plus also item 19.
So which page are we on?
Page 1717.
Okay, thank you.
That KGM Marine has made made payments on behalf of KJI to the tune of just under $4 million. You see that?
I do see that.
So do you accept that KJM put in its own money to the joint venture?
I do not accept that.
And do you accept that KJI has suffered a loss?
Without independent verification, Your Honor, from a what I would deem a top tier auditor, independent auditor, these are just numbers on a page. I don't find any of these reliable or accurate without independent verification.
Well, let's just have a look at one of those numbers. What page 1703? And you see there accumulated losses just under 9 million dirhams. You see that?
I do.
So the auditor here, Unity Auditing, is reporting that the company has suffered a significant loss. You accept that?
That is what is written on this document, yes.
You accept that your relationship with Mr. Al-Jasmi is completely broken down?
No, I do not. I like Mohammed. Every time I see him, we kiss on both cheeks and are very cordial. Frankly, I'm sorry to interrupt you. Go ahead.
When is the last time you saw him?
I want to say there probably the last board meeting that I attended, and I'm going by memory, and I want to say September, October of last year. But I don't hold me to that. But I have not seen them in the calendar year of 2026 that I recall.
Except you've made allegations of misconduct against Baruch.
Correct, and Mr. Al-Jasmi as well.
Yes. And they in turn have made allegations against you. You accept that?
I do.
Do you accept that KGI is now insolvent?
I have no reliable information, nor have I ever been giving any reliable information about KJI, its activities, where my family's investment has been allocated. I have no idea. I've been in the dark from day one.
Except that there is no joint plan for the company's future.
I don't accept that.
Your case is that you don't know how your funds have been used, but we did see in the budget a detailed breakdown. That was at page 913. Remember seeing that?
I do remember seeing that.
And through the course of today, you've given evidence about the frequency with which you visited Dubai and the factory. You recall that?
I do.
So you accept that money was spent on the factory lease, yes?
I do.
The industrial license?
I do.
Some manufacturing process?
I do.
Staff?
I do.
Equipment?
I do.
And we can see here, page 1201. This is the email we've looked at a few times with the bullet points, where you talk here about one prototype, one working version, and 4 to 5 holes in production. I'll see if I can find the precise location for you.
Yes.
So you accept that that's what you had seen by that date?
That's by the time of this email, that's what I had seen, yes.
Yes, and that's, excuse me, I've now found the page myself. It's 1, 2, 3. It's a third black circle bullet point.
Which begins
Which
with
is
a purchase
I-
order has been received dated 10/10/2023.
Exactly. And then your, I think these are your comments in response, saying, I think we have one prototype, one working version, and 4 to 5 holes in production. You see that?
Yes.
So this is not, it would be unfair to say that you were completely in the dark at this point about how your money was being spent. You accept that?
It would be completely fair. I had no backup to anything, how much anything cost. There was never budgets provided or approved in the normal course of business. I had an idea, but I mean, there was no transparency to anything.
Let's have a look then
I
at page one.
saw, to answer your question, Your Honor, I saw money was being spent, but in what quantum and verifiable amounts, no idea.
And let's moving forward in time to the 9th of August 2024, page 1349. This is an email from Mr. Radwan saying that the external auditor has issued a draft of the annual financials through to May 2024. You see that?
I do.
I don't think that document itself has made it into our bundle, but we've seen an audit report up to 31st of December. But you accept that if we look at the attachments there, you're talking earlier about paper clips, we can see there was an attachment. Look at the second one, is called KJI Financial Statement June till May 2024. You see that?
It seems based on this email, there are 7 attachments. Yes.
And so except that you were provided at that time with a financial statement for the company.
I would categorize that, Your Honor, I was provided an unverified page with a bunch of numbers that were essentially meaningless to me.
Well, I suggest, Mr. Rankovich, that the reason everything collapsed is simply that the joint venture ran out of money, and you refused to provide any more money. Is that right?
Well, the joint venture collapsed because I think Mr. El-Jasmi became disappointed that I wanted an accounting of where my money went. And I was perfectly happy, the family was perfectly happy to keep funding the company with accurate information and a full accounting of where the money went, and transparency and corporate governance, which was owed to us.
The reality, Mr. Ivankovich, is that both you and KGM lost money in this venture. Do you accept that?
I don't accept it at all. I accept that we lost money. I have absolutely no idea what KJM took, didn't take, made, didn't make, and I really would like to know that.
And finally, I suggest to you that the letter of termination sent on the 10th of September was valid, and that the relationship has been properly terminated. Do you accept that?
I do not accept that.
Thank you. I am, I think, 1 minute within my extended
You are
time limit.
indeed. Do we have a copy of the lease of the premises?
No, Your Honour.
No copy of the lease. Do we know if it's in KJI's name or KJM's name?
That would be a question for you to pose to Mr. Al-Jasmi tomorrow, Your Honour.
Okay. Well, maybe not. Maybe not.
Your Honor, I have an answer to that question.
Yeah.
I can answer that question. The lease is in KJI's name. I've spoken to a representative of the landlord. I did find out subsequently that Mr. El-Jasmi approached the landlord and tried to get the lease changed to KJM's name, misrepresenting to the landlord, according to their agents, that the companies had merged. The landlord's representative informed me that he asked for evidence of that merger from Mr. Al-Jasmi, which he didn't provide. So he didn't change the name of the lease to KJM. And that, as far as I know, the last communication with the representative was in January of this year, that it was expiring, but being extended in KJI's name.
Okay, thank you. Mr. Watson, I've got a couple of questions for Mr. Ivankovich. Probably better if I ask them before re-examination.
Well, I can assist in that I have no questions in re-examination.
You have no re-examination. Well, in that case, that makes life easier. Just one very simple question, Mr. Ivankovich. From my reading, I'd rather thought that Octopussy was the Sunseeker, but it's not. It's another boat, is it?
Yes, it's a 150-foot Heeson that was specifically carved out of the joint
150
venture.
foot. Sorry, what?
Heeson. It's a Dutch builder.
Okay. How do you spell that?
Heeson, Heesen.
Thank you. Okay, and that you said was carved out.
Yeah, it was a vessel the family owned. In the construction of the JV, we were both contributing to avoid conflicts of interest. All of our maritime activities into KJI, but we specifically requested that the Octopussy be carved out of that activity, which it was in the JV.
Okay. Next question. Can we just go to the loan document at page 904, please? Do you have that before you?
I do, Your Honor.
Yeah. Okay, so the object of the loan is expressed there for the purchase of the vessel from Sino Eagle for 3.99 million. And KJM undertook clause 4A to purchase the vessel. Did you ask for evidence of the contract of purchase at this early stage?
At this early stage, no, Your Honor. And
why not?
Well,
it's the basis of the loan agreement.
Yeah, so the reason the loan agreement came up and it wasn't structured the same way as the Sunseeker. So in my mind, according to the reading and the intent of the JV, was we would advance money outside of this loan agreement to purchase the Aquila. It would be part of the JV. It would be sold, and that revenue would become revenue of the KJI company. Mr. Al-Jasmi was really pushing me to do this transaction. I really didn't want to do it, but I didn't want to, what if there was a way to make this? I wanted more than the 50% contemplated. So we structured it as a loan where we believe there was security, but again, we didn't contemplate that we would have to. We thought we would be given transparency to the contract, but it was in fact KJM that was guaranteeing this loan, backed by Mr. Karafi. So we thought our money was safe, and that they wouldn't do silly things when purchasing this boat.
But didn't you want to see documents of title and indeed the the contract with the yard? I mean, you need documents of title for insurance, classification, you name it.
We did, and that was requested in numerous emails by Mr. Moore and was never provided to us.
But that's later on. I mean,
Yes.
I'm going back right to the beginning. I mean, why didn't you want to see that documentation to know that there was a boat, the conditions under which it was being built, and that it would be seaworthy?
Well, the boat was built to our understanding, and perhaps in my naivety, Your Honor, I never would believe that we would, at that point of the relationship, that we would be treated in such a way by our partner, especially when we both had a vested interest from making a profit of this.
Okay, well, let's then fast forward to when the scales will have fallen away from your eyes,
Yes.
and the to use the back end of relationship. So you're being told that it was a condition of the contract with the yard that the 1.6 million was forfeit.
Yes, we were told that
So
much later.
didn't you want to see the contract at the time you were told that?
And we did ask for it then, absolutely.
And you asked for it, but didn't you want steps taken against the yard to try and recover the money?
We took steps through Mr. Hand to directly contact the yard, to go out and travel and see the yard. We were informed by a representative of the yard that they were informed by KJM not to directly deal with us. Yes, we took those steps post facto to try and buy the boat directly from the yard, to visit the yard, to let them know that we were the funder behind this. And my understanding through the conversations with Mr. Hand is that that transparent, open dialogue was actively being blocked by KJM.
But what about proceedings in China against the yard?
Oh, Your Honor, I'm having experience in China. I think the answer is it was determined that we wouldn't have standing to make proceedings against the factory, since the relationship or purported contract would be between KJM and the factory. And that would just be good money after bad.
Okay, I understand that. Any questions arising out of what I've just asked, Mr. Page?
Not from me, Your Honor.
Any re-examination out of what I've just asked, Mr. Watson?
None from me, Your Honor.
Okay, well, in that case, thank you very much, Mr. Ivankovich. It is, I think, approaching 8:30 in the morning for you. Have a good rest of the day.
Thank you, Your Honor. I think I'm due a Bloody Mary at this hour.
You probably are. I will see then everybody else tomorrow morning at 11 a.m. Dubai time.
Thank you, Your
Thank you
Honor.
very much indeed.